2023. We're being hosted at the Banking Institute here at Uganda Road. My name is Keith Namara Charuzi, and I'll be your host today. And I'm excited because we have a great lineup of programs that you will be benefiting from. I begin by bringing apologies from the CEO of Uganda Law Society, who has not managed to make it. He was meant to give the opening remarks, and it does seem that I have stepped in the CEO's shoes. I hope that I will not have usurped his powers. But nevertheless, today's program is action-packed. We will be having speakers talking about a range of topics from sustainability standards in the financial sector, legal dimensions in electronic fraud. We'll also later in the day have discussions on Islamic financing. I'm sure that most of you have heard a thing or two about Islamic banking. But we will cap the day with key tax considerations for the financial sector. Now, to begin us off is Mr. Parteka Emmanuel, who is the head legal from Post Bank. Mr. Parteka is going to be talking about sustainability standards in the financial sector. So we anticipate to learn about ESG goals for different financial institutions, things like renewable energy financing. What options does a financial institution present out there to a customer who is interested in things sustainability? So without wasting any more time, I will introduce Mr. Parteka. Please take center stage and tell us more about sustainability in the financial institutions.
Okay, thank you, and good morning, colleagues. As introduced, my name is Parteka Emmanuel. I'm the head legal service at Post Bank, Uganda Limited. I'm presenting a paper on sustainability standards under the topic, why all Ugandan financial institutions should enlist for the Sustainability Standards and Certification Initiative, that is SSCI. The first version of my paper was published on the New Vision and Daily Monitor online platforms, but it's also available on SSRN e-library. During my presentation, I'll give a brief introduction about SSCI. I'll give the background or the history to it. I'll state the assessment parameters for SSI. And then I'll talk briefly about the versions that have been developed under SSCI. Then I'll talk about the difference between ESG and SSCI. Okay, and then why financial institutions should enlist for sustainability. And then I give a conclusion. So to start off, I want to define what sustainability is in the line with financial institutions. And this can be defined as being resilient and value-driven by considering the needs of the current generations and society in which they operate without compromising the needs of the future generations. Now, three aspects here to note. There's resilient and being value-driven. Now, being resilient means that the financial institution is able to withstand any shocks in the industry. For example, when we had COVID, if you've been following financial statements of most institutions, they were hit badly by the bad loans. So, how resilient is a financial institution to withstand such shocks? How can they adopt new technologies that don't hinder the environment or the society, that can support them in having collections even when there's a lockdown? Then being value-driven means that the financial institution must be solid, financially solid. It must make profits, okay, but also in a way that does not compromise the needs of the future generations. What does that mean? A financial institution should be able to give out loans, but finance activities that support the environment, okay, or activities that support the growth of the economy through creating of more employment and having sustainable businesses. The standards were developed by the European Organization for Sustainable Development, that's EOSD. And according to Mr. Ashab Rab is the CEO of the European Organization for Sustainable Development, and is also the chairperson of the International Sustainability Council. So, according to him, sustainability standards are a business imperative for any financial institution that is trying to survive and thrive in this new world, which is characterized by frequent shocks and high uncertainties. Now, so this basically means that the standards were created to enable financial institutions to withstand any changes in the industry. I gave the example of COVID. You can give the example of the numerous changes in technologies that come up now and then. We now have AI that is coming up now. So all those technologies must be withstood for the betterment of the institution, of the financial institution. The standards were developed to be ever evolving so that they always deliver solutions to the sustainability certified financial institutions throughout the changing and increasingly challenging times. So for sustainability to be realized, it must be embedded in the financial institution's corporate strategy. So when the financial institution is making its strategy for say 5 years or 5 years or 3 years, it must embed sustainability in that strategy. So an institution has to develop a purpose statement and high-level goals. The purpose statement shows why an entity exists and what drives it. And the high-level goals are derived from the purpose statement. They, meaning the high-level goals, speak to how the purpose statement will be achieved. So for an institution to have sustainability, it must have those two, the purpose statement and the high-level goals. The purpose statement is the major focus of the institution. What is it driving at? Is it driving at financial inclusion? Is it driving at having renewable energy? What's that major focus that the financial institution is driving at? Then it will come up with high-level goals to sustain that purpose statement. Just to give a background which will speak to what I've stated earlier, the standards and the European Organization for Sustainable Development is based in Germany, and it is a globally recognized body that has in its unique charter the purpose of developing strategies, programs, and initiatives that contribute to implementing the European Union's strategy for sustainable development. It's one of the oldest global players in sustainable banking and finance, delivering highly impactful targeted initiatives for creating a sustainable economy. The history of EOSD dates back 2007, while its Europe-wide activity started in 2010, when institutional partners from Belgium, England, France, Germany, Ireland, and Netherlands united under the EU-funded initiative to stimulate the innovative capacity of SMEs and support the transition to low carbon and sustainable economy. So this is a body which started in Germany, and it mainly emanated from the European countries. And the main purpose then was to transition to funding of low carbon companies and also having a sustainable economy. So since 2011, the European Organization for Sustainable Development has had various milestones, including the launch of the Sustainable Standards and Certification Initiative for value-driven financial institutions. So the standards for financial institutions started in 2011. Okay. The EOSD is the first and only initiative worldwide enabling financial institutions to embrace sustainability holistically across the board in their organizations. SSCI delivers a holistic, robust, evolving, and locally sensitive set of standards to make vault-driven institutions resilient and profitable. So the standards are localized to speak to the prevailing situations within a country. So when these standards are developed, they're developed according to the local setup of a financial institution. Okay. SSCI was developed based on the conviction that financial institutions are uniquely positioned to lead the process of sustainable economic transformation in their respective countries. SSCI therefore delivers cutting-edge sustainability standards for creating strong, vault-driven, and profitable financial institutions. Many banks world over have been certified by EOSD, and in Uganda, Uganda Development Bank and Pride Microfinance Limited have received the sustainability certification. In pursuit of this very important certification is the regulator of financial institutions in Uganda, that's the Bank of Uganda, Post Bank, and Housing Finance Bank. All these banks, to note, is that they have been accepted to the sustainability standards and certification initiative, and they thus have been granted certificates of acceptance by the International Council of Sustainability Standards and Certification. It's worth noting that only reputable financial institutions around the globe are pre-qualified for SSCI certification program and are required to have demonstrated a strong commitment to sustainability. So this is important to note because not every bank or not every financial institution can be enlisted for this certification. There are a number of parameters that have to be undertaken before a financial institution is even given acceptance to participate in these standards. And my next speak is on the assessment parameters for SSCI. Financial institutions that apply for SSCI certification are assessed on 8 principles referred to as the octagon value creation model. These 8 principles cover areas of governance, management, technology, business models, operations, products, stakeholder relations, human capital. Now, governance basically speaks to the institutional stability. You're talking about the board composition, the governance of the institution. Then management, you're looking at the senior management team and how they derive sustainability. The business models, or before that we talk about the technology needs to, they look at the technology that makes access to financial services easy and how everyone can access the financial services. And I can give an example of Post Bank, which has developed a wallet called Wendy that is a mobile bank and can be accessed anywhere in Uganda. Then we have the business models. This speak to the needs of the people. The financial institution has to develop business models that include social, environmental, and technological considerations. So the business model should cover or should speak to the needs of the people. Then the operations of the bank or the financial institutions ensures that organization resources are utilized optimally, and it lowers the income to cost ratio. So the operations of the financial institution should be efficient enough to lower that cost versus the income of the financial institution. Then the products should support the economy through job creation. If the financial institution is giving a loan, it must support entities that can, for example, create jobs that can employ so many Ugandans. And as the Minister of Finance has already said, the biggest problem in Uganda is the low employment levels. So a sustainable financial institution should support entities that can create jobs for Ugandans. Then the stakeholder relations speak to to the good relationship which must exist between the different stakeholders like the customers. The relationship between the customers and the bank or the financial institution should be good enough to promote that business. Then the human capital, the financial institution is supposed to be intentional in training staff and also ensuring that they have a good working environment at the workplace, because it is the human capital which ultimately serves the ultimate customer. Then I'll speak about the versions under the SSI. The SSCI has had about 2 versions, and the first one was version 2.0, which was developed before the outbreak of COVID-19. The current version is 2.2, which emphasizes crisis readiness and has also included aspects of risk management. This was a reaction to the COVID outbreak, which was not expected. It just came up abruptly. So it was developed to ensure that financial institutions come up with the policies or decisions that can shield them from abrupt occurrences in the industry. Now, let me speak about the environmental, social, and governance versus SCCI. Both environmental, social, and governance, or ESG, and the sustainability standards are platforms or vehicles that are used to achieve sustainability. Okay? And ESG basically refers to a set of criteria used to assess a company's environmental, social, and governance impact, while sustainability is the capacity to maintain or endure. So sustainability is looking at how a financial institution can endure through any circumstance that comes up. So while both terms may somehow overlap, SCI is more encompassing because it encompasses ESG, and it covers a more aspects than ESG. I'll come to the last aspect of my paper, which is why SSCI. Why should financial institutions enlist for sustainability certification? One is that sustainability certification enables institutions to be highly competitive in an increasingly crowded financial sector, and clearly distinguishes them from those institutions that have not fully embraced sustainability. So the financial institution is overly crowded, as you may have noticed. We have now fintechs, we have money lenders, we have microfinance institutions, we have banks or commercial banks. So it's overcrowded. So what will make a financial institution stand out is its ability to be sustainable. And I think you've noted and read about so many banks that have closed recently, even in established economies. So the issue is about sustainability. How can a financial institution live beyond 50 years, 100 years to eternity? Secondly, SCCI promotes institutional sustainability. This basically refers to the proper working or functioning of an entity. Governance is the heart of an institution, and if an institution is not well governed, then it can easily collapse. So sustainability standards come up to check institutions in their governance standards, and therefore by that the institution is sustainably maintained, and therefore the institution does not collapse anyhow. Thirdly, when a financial institution is strong and resilient, it makes the country's economy strong, while at the same time protecting its natural environment and promoting inclusivity within the workplace. So what sustainability does is that if a financial institution is funding a customer or an entity, it checks the purpose of the loan. Okay? And therefore, you may not find an institution which is sustainable cannot fund deforestation or cutting down of forests, but you will find planting of trees. Okay? So a financial institution which is sustainable, has that in their framework, in their policies when they're giving loans, that financial institution will go a step ahead to train its customers on how to use the money, to ensure that the money is put to good use that protects the environment. SSCI is also a major enabler for accelerating impact investments and moving sustainability-centric investments from niche to mainstream, and also closing the gap for achieving the Sustainable Development Goals. Impact investment, if I may define it, is a type of sustainable investing strategy where an investor seeks financial returns alongside a measurable positive impact on society or the environment. So what sustainability does is that it balances between the profits that the financial institution is getting and the environment or the society. Okay, so a financial institution will not just give money, but it will make sure that that money is purposeful, and that money is going to protect the environment, but also it is contributing to the society through creating employment. Lastly, SSI is designed to be highly responsive and adaptable. It promotes organizational agility and also resilience to crises such as the current coronavirus crisis, which requires a targeted response to ensure business continuity. So SSCI makes financial institutions to develop strategies that can help them in tackling issues that may come up that were not planned, like when we had the corona outbreak. So it promotes continuity of the financial institution. Okay, even if there's a lockdown, people should be able to pay their loans. Okay, even if there's maybe a political situation in a country, people should be able to receive their money on their phones. They should be able to pay their loans. There should be continuity in the business. So the standards help financial institutions to frame standards that can help them in being agile, okay, and also resilient to any shocks in the business. Conclusively, as I conclude my paper, SSCI is an enabler for growth, and also helps in achieving the UN Sustainable Development Goals and Uganda's Vision 2040, which is monitored by the Uganda Planning Authority. So sustainability is a key tool that should be taken up by all financial institutions in Uganda. I thank you.
Thank you very much, Mr. Parteka, for that rich, full discussion on sustainability. And you did make sense when you talk about things to do with ESG and renewable energy stuff. And also, mostly people have thought sustainability is about climate and climate change and renewable energy. But there's a corporate social responsibility arm of sustainability. I anticipated some questions in the chat because you do have about a couple of minutes onto your time, but running through the chat, I seem not to see any for you. I just want to ask you one question before we move to the next speaker. Sustainability and the conversation about it is beautiful. I just want to know what the appetite is for the financial institutions. Is it something that, because at the end of the day, a financial institution has to make profit. So you do put your money where it counts. At the end of the day, what is the appetite for financial institutions taking on, for instance, giving products in the sustainability space versus the uptake of these products? Are you seeing the public out there come for loans to plant trees, for instance? Are you seeing a lot of uptake from the public? And are you, as a financial institutions, geared towards giving out loans for such purposes.
Okay. Yeah, thank you. So, sustainability should not be looked at as a tool that is there to stifle financial institutions from getting profits, but it should be looked at as an enabler, like I said. So what happens is that if you embed sustainability in your policies and procedures for the bank or for the financial institutions, you become intentional at financing activities that will make, first of all, the financial institution to be sustainable, but also the entity you're financing should be sustainable. Okay. So what that means is that the financial institution will support a customer that is going to be there for a long time. You're not giving a one-off customer. You're investing, you're financing a customer or an entity that is going to be sustainable, that is going to set up a business that's going to be sustainable. Okay, so that business in the end is going to create jobs for people, and those people getting jobs are going to become your customers in the long run. Okay, so that's the sustainability that I'm talking about. So it's a cycle. As the bank, you're looking at the future, looking ahead, you're looking at so many years to come. So it's going to be a cycle. It's going to be from the customer, from one customer you get more customers. Okay. As I'll talk about Postbank, we are financing customers who are doing renewable energy, solar. We have entities who are getting loans in solar. We have entities who are offering clean water to customers. We call it wash loans. So all those are geared towards sustainability. We want the customer to be sustainable, but also the bank to be sustainable. But also the other thing is that we're also investing in technology to ensure that there's continuity. So even if a customer is in the remotest place in Uganda, he or she can access money on his phone, even a normal phone that is not a smartphone. Okay, so even when there's a lockdown, that customer can be able to bank. Okay, that person can be able to receive money, they can be able to pay their installments. So that's sustainability. Thank you.
Thank you very much, Mr. Parteka. That has been Mr. Parteka Emmanuel. He's the head legal at Postbank, and he has been discussing sustainability standards in financial institutions. He's going to stay a while until the end of the program, where you will be able to ask questions. Those of you who are just joining in, or those who are now just formulating your questions, remember, post your questions in the chat. I'll be able to pick them up for the different speakers to answer. Remember that this is the Banking Law Symposium, held under the auspices of the Banking Law Cluster of the Uganda Law Society. The Banking Law Cluster is just one of the groups, the many groups under the Uganda Law Society, where different people with a keen mind on the banking sector and keeping up trends in the banking sector come together to exchange ideas and further the agenda of the banking sector. And I'm going to now introduce our next speaker, Agatha Ninsima, who is a partner at Yencha Chihika and Company Advocates. Agatha is going to be talking about legal dimensions in electronic fraud and how we can protect core financial systems from this digital age. There's been a lot of developments coming up in the fintech space, a lot of innovations day in, day out, and all these pose a challenge in some sort of way. So how do us as lawyers play a part in solving some of these challenges? To discuss this and more, ladies and gentlemen, please make welcome to Agatha Ninsima.
Thank you. sharing the slides? Or not?
You could share them
Yes, I
on the group on WhatsApp.
Okay.
Then I'll give them. You can start talking now.
All right. Thank you. Thank you for that introduction. I'll just get right into it. In exploring the legal dimensions in electronic fraud and how you can protect financial systems in this digital age. Briefly, we are in an increasingly digital world, and the convenience that comes with online banking and financial transactions comes hand in hand with heightened security risks. And therefore, as bankers, but also as customers and lawyers, we need to be aware that these cyber threats will continue to evolve, making it essential for institutions, financial institutions, as well as individuals to take proactive steps in safeguarding the customer's finances, but as well as our own finances that we put in these banks. The current trends really, consumers now can access their banking services using their phones, thanks to mobile money banking, to mobile banking, but also to mobile money, as well as agent banking. You no longer have to go to the brick and mortar kind of banking that our fathers and grandfathers did use. Some banks like ABSA have actually gone ahead to advance technology to the point where one can get money from anywhere using a QR code. And the previous speaker did talk about the sustainability. And because there's so much emphasis on sustainability, as well as data privacy and cybersecurity, there is more need for financial institutions as well as individuals to be aware of the cyber risk that arises as a result of this advancement in technology. Technology is a major pillar, and it is here to stay. And any significant investment that is made in this digital transformation, as well as skilling, is required so as to provide the necessary value to not just consumers, but also to guard against the cyber risk that comes with this advancement in technology. The regulator, that is the central bank, and other stakeholders are always discussing ways to improve the financial inclusion, but as well as the risks that are associated with the threats that come with these electronic transactions. So, aware of the trend and the need for flexibility as well as convenience in banking, our regulator, the central bank, that is the chair and the secretariat for the Financial Sector Stability Forum, which brings together all the regulators in the financial sector. The focus really of this Financial Sector Stability Forum is to standardize. And I know in terms of regulation, there's a time where there was a bit of overlap in regulation. There were some regulations that had come out from UCC in terms of digital payments, but BOU also has revised and amended the existing cooperation agreement with UCC, thus enhancing the common conversations regarding digital transformation. Because electronic transactions really overlap from banking to telecom, you find that UCC is also a major stakeholder, and UCC does prioritize open communication with other regulators. For example, UCC served as a co-chair when the National Payment Systems Act was being prepared and enacted. And so going forward, to avoid conflict, there's an MOU between UCC and BOU that precisely outlines each regulator's responsibility. UCC undertakes a regulatory impact assessment to ensure that all other authorities are involved and that there are no conflicts, as well as coordination with sector participants. The previous speaker did talk about how there are fintechs in place. There's the banks that, as we know them, in place. There are different other stakeholders that are in play in respect to this particular area of practice. Let's go straight to what does electronic fraud mean? Electronic fraud, really also known as cyber fraud, refers to the fraudulent activities conducted using electronic means such as computers, internet, or mobile devices. It encompasses various illegal activities like identity theft, malicious software. There's employee-initiated fraud, where employees of the banks do actually initiate some of these fraudulent transactions. There's fraudulent email, which is also known as phishing. There's also e-transfer interception fraud, as well as SIM swaps, online scams. There's also the ATM card fraud. There's a time in Uganda when this was a common kind of fraud, where these fraudsters would target withdrawals at ATM cards, and somehow they would tap into a customer's ATM card details and take out the customer's money. What is the legal framework in place at this time that we are having this particular symposium? There's the Computer Misuse Act of 2011 that does criminalize this electronic fraud. There is the National Payment Systems Act of 2020 and regulations. We also have the National Payments Consumer Protection Regulations of 2022 that have come in to reinforce this particular area of the law. And as lawyers, really, maybe you would ask yourself, why should we pay interest in this particular area? Because the central bank is already regulated this space, but also as a lawyer, you're also a customer of the bank. You do put your money in these banks, and no one is immune to this electronic fraud. So it's not an area that is far-fetched, whereas banks are reinforcing their side in terms of software and technology advancement to ensure that they protect the customers' deposits. Also, as individuals, we need to be up to date and be aware of the different ways that money can actually be fraudulently taken out of our bank accounts, or how our transactions online can be intercepted by these fraudsters. Because as we are there leaving our money in banks, there are people who are studying these systems and are more actually skilled than some of us in terms of interception of online transactions. So it's important that all of us are aware of the different ways that money can be intercepted or fraudulently removed from our bank accounts. So let's go into the legal framework. We spoke of the Computer Misuse Act, and it's defined what electronic fraud is under Section 19, and it defines it as a means of deception deliberately performed with the intention of securing an unfair or unlawful gain, where part of a communication is sent through a computer network, or any other communication is sent through, or any other communication and any other part through the action of the victim of the offense, or the action is performed through a computer network, or both. And this particular Section 19 does criminalize this particular electronic fraud offense. It says a person who carries out electronic fraud commits an offense and is liable on conviction to a fine not exceeding 360 currency points or imprisonment not exceeding 15 years or both. This particular section, we've seen it at play in courts where several persons have been brought to book under this section, and it's been tested, and persons have been convicted for committing electronic fraud. There's a case, an anti-corruption case of Uganda versus Sentongo and 4 others. In this particular case, these 5 persons were actually indicted for various offenses, and including electronic fraud. And I will not go into the details of the case. It will be provided in my presentation. But in this particular case, because these persons who were actually employees of a telecom company had engaged in this electronic fraud that has been defined, they were actually convicted and were liable convicted, and they were liable to pay the fine that is prescribed under Section 19. Let's go to the next law that's in place. That is the National Payments Consumer Protection Regulations of 2022. Under this particular regulation, really, what is key is consumer protection. And when we are looking at consumers, we are looking at the persons that are actually partaking of the service that is being given. For banks, this would be the customers that bring deposits. For fintechs, it's persons that actually upload the apps on their phones and actually use them for payments. And so this particular regulation is very specific in terms of protecting the consumer. And for several years, there was never a regulation to protect consumers, but this particular one has reinforced and requires that any person who's licensed under the National Payments Systems Act should develop and maintain a consumer protection policy which is consistent with the regulations. And this policy is to be reviewed every 2 years. And this revised copy is to be submitted to the central bank, indicating the changes, any changes within 30 days. Failure to actually submit this or to comply with the need for this consumer protection policy invites a penalty of 250 currency points for each day of default. And so this particular regulation is a welcome regulation because it does go ahead and require financial services providers to actually put in place this policy that has several key provisions, and one of them is the roles and the responsibilities and training of staff members. Like I mentioned earlier, that some of this electronic fraud is initiated by employees of financial institutions, employees of these digital financial payment service providers. So the consumer protection policy should have the clear roles and responsibilities and the training of staff members in terms of consumer protection. It also provides for control mechanisms to safeguard data, because with online and banks do collect our data, and sometimes fraudsters do use this data to actually intercept payments, and so a control mechanism is required to be put in place to safeguard this data. And that brings in the issue of information sharing mechanisms. So in this policy, there should be a clear way on how the customer's information is being shared. There's also a need for accountability and transparency and complaint handling processes, because you find that many people actually do encounter this electronic fraud, but then they are not aware of the complaint handling process. They don't know the dispute resolution mechanism in place. And so this policy should be elaborate on that particular process. We are seeing people going on social media talking about their predicaments, yet if financial institutions could clearly state what the complaint handling process is to the customers, then we would reduce, not that it would take away people going out there and lamenting, but it would reduce some of these incidences. And then in addition to that, the policy, this is the consumer protection policy under the National Payment System, should also have an annual consumer protection audit. It's continuous auditing of the systems in place. In addition, they should conduct an annual quarterly internal risk assessment. As financial system service providers, it's important that you have an internal risk assessment to see the risks that have been faced by your company at any given time, and also try and see if there are some that you could safeguard from happening in the future. And in addition to all this, the policy should have any other matter the central bank may direct in writing. So this particular policy is customer-centric in such a way that if a licensee does not put these measures in place that are required, then they are liable for the loss or misuse of the assets of the consumer, and they are required to make good of that loss unless the damage was by the consumer's negligence. And in case of an employee, in case there's it's an employee of the licensee, then the employee will be liable for that particular loss. What is required of the service provider, the licensee, is to actually take disciplinary action against the said employee. And we have seen recent cases where some banks have taken disciplinary action against employees that have been involved in this electronic fraud. But that as it may be, we have also had decided cases where consumers or customers have been held not liable, but they have been told that the duty to protect their information lies with the customer, because the relationship between the banker and the customer, each one of them does have a role to play, whereas the bank is supposed to safeguard and ensure that there is no unnecessary withdrawals without the consent of the customer. Even the customer has a duty to play in safeguarding their information, their passwords, in safeguarding their ATM cards, in safeguarding their mobile telephones. In case your customer's mobile telephone is stolen, it's the duty of the customer to actually inform the bank and even lodge a complaint for the loss of their mobile telecom. You find that many of us, including some of us today, we do not actually log out of these platforms because you don't want to forget your password. So your phone is automatically logged on 24/7. So in case your mobile phone is stolen, it is so easy to actually access some of your information on your phone. And so in a decided case of Ida Atiku versus Centenary Bank, civil suit number 754 of 2022. In that case, Honorable Justice Stephen Mubiru did find that the customer had a duty to, this particular case concerned an account holder who had lost a substantial amount of money that they had deposited in their account due to unauthorized transactions, and the court was put to task to actually apportion liability for the loss suffered due to these unauthorized transactions. And the court ruled that the party who is best placed to prevent a fraudulent activity will bear the loss. And in this particular case, the court found that the loss lay with the account holder, as the account holder had negligently allowed a third party to access her bank account, leading to this particular fraudulent transaction. In this case, the bank, Centenary Bank, was not held liable as the bank had put in place commercially reasonable security features which the account holder had jeopardized. And the question then would be, what are these security features that that need to be put in place to ensure that that your money or the money of the customer is protected. So one of the features is to implement strong access controls to ensure that not everybody has access to the systems that the bank has to safeguard these online transactions, but also to regularly update and patch systems. You find that as technology advances, even the fraudsters out there, their knowledge does actually advance. So if you do not do regular updates and patching up of your system, then you will be prone to actually these fraudsters, because there are people who are there day to day, day and night. They are studying these systems and they want to see how to actually penetrate them. So the regular update is needed. Then also encrypt sensitive data, and I've seen some banks actually do this. If they're sending any information to actually to a lawyer, it's always encrypted. Some banks do encrypt that information so that not everybody will have access to the customer's information. And I find that banks that have actually adopted this approach have a better safeguard for this data that comes to them. If you have this in place, then you are not prone to these fraudsters. Then conduct regular security audits. This I mentioned before. Don't just put in place a security feature and leave it. Try and do an audit on a regular basis to see if actually this particular security feature you have can be penetrated, or someone has attempted to penetrate the security feature that you have put in place. Then educate and train users, not just the customers, but also educate and train the employees that you have. Because like we've seen that some of this electronic fraud is actually initiated by the staff that these the financial service providers have. So train your staff about the need for protection of customers' accounts and money, but also train them about these systems that you put in place. And if you train and educate, the employees will know that in case it is employee-initiated fraud, they will be liable not just to fine but also to imprisonment. But also the customers need to be educated. I know that banks do have the KYC, and at the beginning you might think that the customer has actually understood when they sign some of these documents, but you need to do a regular training and update of this particular area of the law, because some customers do sign for these digital services, but then they do not actually know how to safeguard from fraud. They will not know which maybe the callback call from the bank. They don't know the phone number that will call them for a callback in case they want to confirm a payment. They do not know where to actually report in case of an incident. So there is need for continuous education and training, both for the staff but also the other users. And then also there is need to implement endpoint security measures, as well as to engage with cybersecurity professionals. I think that we need to get away from trying to save money and move to actually getting actual professionals who are well aware of how to safeguard systems that we have put in place. Because I don't see why you should invest so much money in getting a security system, but then you don't have an internal cybersecurity professional to safeguard your institution as well as the customers from these online fraudsters. So we've looked at the legal framework, we've looked at how one can protect, how to protect these financial systems. I just wanted to also tap a bit on how to actually fortify the financial defenses, because I know that they could be here lawyers, bankers, but also I know that there's a non-lawyer that's logged on. And how do you actually fortify your financial defense? One is have a strong password. Don't have a password that is your name or your birthday. I know passwords are so many. We're on so many online systems, and so you find you have like 10 or 20 passwords, and you find there's one password that you're using across all these particular online systems. But try as much as you can to switch up your passwords. Have uppercase, lowercase characters, so that it's not obvious. If I'm going to tap into maybe your online banking on your phone, I don't just put your name and your app opens automatically. And then the second one is the two-factor authentication. I think most, if not all, payment systems do have this. This really is about having an extra layer of protection to verify any login system. So before accessing your account, what some people do is when you put in your password, it's usually a code is sent to your mobile phone that you used at the time of actually registering maybe that online payment system. So that extra layer does prevent actually fraudulent transactions, because if someone does not have your mobile phone at that particular time, then it's unlikely for that transaction to actually take place. Then use secure Wi-Fi. Really, I think as the service providers train the users, they need to emphasize Ugandans love free things. They want to log on to Wi-Fi. When you reach in a place and you see a Wi-Fi password, you really want to log in and use it immediately. But the truth is, there are people that are around that place who know this password, who can this Wi-Fi password, who can actually intercept and tap into your electronic devices in that particular place. So when you reach a place, don't be in a rush. Oh, what is the Wi-Fi password? You're in a restaurant, you want to tap into the free public Wi-Fi. Please resist, especially if you have your online banking app open on your phone. Please resist from this particular habit. I know we love it, but if you want to secure yourself from this electronic fraud, you need to actually put in place some of these safeguards. But also educate yourself. Educate yourself on simple things. One of the common ones is when you're going on a website, when you're on your laptop and you're opening a website, there's always cookies, different cookies there, and there are options of accepting all. There's an option of actually managing those cookies. There's several measures in place, but you'll find someone is in a rush. They just accept all. You don't know their back-end users that are actually intercepting this login for you. So please resist from accepting everything that is given. I know we love free things, but sometimes these free things, that's why you are prone to not just domestic fraud, but also international fraud. I know some people are still using what we used to use when internet was off. So you're still using it to actually access prohibited sites. Please resist from tapping into things you're not sure of. Then do regular software updates. Some of us are lucky that we have people that will do software updates for us, but if not, sometimes there's a prompt to actually update. The way you update your normal social media platforms, please update softwares that are in respect to your online payments. Also be inquisitive to know what are the updates in place, what are the updates from your service provider, what are the updates on the market, both for the bankers but also for the customer. Be inquisitive to know what are the other competitors using to safeguard, because you realize that there are some financial institutions that are consistently in these issues of electronic fraud, but there are some that are actually you don't hear them in these spaces. So be inquisitive to know what actually others are doing to protect themselves. And before we go to the final bit of it, I talked about how the policy that is the consumer protection policy should that is to be developed by the licensee should have certain things, but there's something about consumer education and awareness as well. The licensee is tasked to develop and conduct consumer awareness programs tailored to the category of the consumer, because consumers are not on the same level. So when you're developing these awareness programs, do not have one that fits all. You need to know the kinds of consumers that you have for the products that you have. So tailor-make your education and awareness for each category, and conduct programs through public awareness campaigns. We've seen some of these people coming on radio, coming on TV, to empower the consumer, to ensure that the information awareness is developed in English, but also translated into other languages based on the geographical location and the need for the consumer. So once a service provider does create an awareness or develop an information awareness for the literate, if it's in English, if you're going to my village in Tungamo, please make it tailor-made for those people so that they understand how to protect themselves even in their geographical location, but also meet the needs of those people. And then I don't want to leave without talking about data protection. I think I hinted on it, but with electronic fraud does come data. Someone has to intercept in the data so that they can tap into this financial information. So consumers are required to update their record as and when the need arises with their service providers, but also the Data Protection and Privacy Act of 2019 does apply in terms of protection of consumers under the National Payments System regulations. And security and control measures need to be put in place to protect the information or data of the consumer, who is a body corporate or an individual. And so the licensee is tasked under these regulations to develop training programs, assess the training needs of its staff and agents at appropriate intervals, provide continuous training. I will not stop emphasizing this, because I find that the reason we have so much, it's because of the information gap that we have, and employ competent staff and review competency of the staff that you have, because some people have staff that are very money hungry. They are willing to trade customers' data for financial benefit. They are willing to actually assist fraudsters to take out people's money. So continuously review the competency of staff and train. So finally, what are the key takeaways that banks need to have, or consumers or customers, or even us as lawyers? What are our key takeaways? In terms of banks, really, there's need to have these consumer protection policies. If you don't have, or if you have, please continuously review them to ensure that you are double protected. Don't leave room for someone to be ahead of you in terms of putting in place security measures to safeguard your platforms. But also, as customers, the common law duty on the signatory of a contract in case of a bank of a bank customer lies with that particular signatory. So as an end user, as a customer, as a consumer of these products that are there digitally, you have a duty to ensure that you protect yourself as well from fraudulent transactions, especially the ones that are within your control. Sometimes you find that persons that intercept these payments are people you know, your family members, your friends, the people that you know how you actually transact. So you have a duty to protect your ATM, you have a duty to protect your passwords to your online banking or your online transactions. If you're buying things online and you're required to put the last digits on the back of your card, let not a third party know those digits so that they can actually transact from wherever they are. Even when someone does not have your card, they actually know the digits to put in to make purchases online. But also banks have an obligation to the customer and the associated risk of fraud in digital banking to ensure that they safeguard their system and also handle the competencies of their staff to ensure that their deposits are protected and not interfered with without their consent. And then finally, there's always fraud where there is money. You cannot separate the two. When someone, it's like, even if not in the digital age, but even in the normal circumstances, when there is money, there is someone that wants to take that money. If someone knows you have money at your house, there will be robbers that want to come and take that. And so in this particular instance where we are in this digital age and everything is happening online, and we cannot say that we shall not transact online because it is very convenient. You don't want to go to the bank to withdraw every time. You can, you need to be able to move your money from your bank account to your mobile money. You need to be able to make payments in supermarkets on your phone. You need to pay for anything you want online without necessarily going to the bank. And therefore, for us to protect ourselves, we need to be in the know. We need to be equipped with the knowledge on how these particular transactions, these fraudulent transactions happen. They come in so many forms, really. They come in so many forms. And so educate yourself and get to know how you can protect yourself as a customer, but also on the part of the financial institution, on the financial digital payment service provider. Please put in place systems and do regular updates, do regular audits to ensure that you are well safeguarded, you're well protected as a service provider. Don't have the weakest system in place that everybody can actually tap into. As I end, I want to say that protecting one's finances is not a choice, it's a necessity. Unless you do not want to protect your resources, someone will take them. There are people there that have put in time, that have put in hours, and they have read and they know how to actually intercept payments, but also to trick people that are not strong-willed. If you are able to give away your password, if someone calls you and says you've won money that you actually did not work for, there's no free lunch, there's no free money in this country. So protect yourself so that you're not a victim of electronic fraud. Thank you very much.
Thank you very much, Agatha Nisima. Agatha is a partner at Yencha Chihika and Company Advocates, and she has been taking us through a discussion on exploring legal dimensions in electronic fraud and how to protect core financial systems. Just to remind our audience out there, please keep the questions coming. I am taking note of those questions that are being posted in the Q&A, and some of them are going to be attempted during the speaker's slot, but most of them are going to be answered in the Q&A session that is just after the last speaker. I noticed that there is actually one for you, Agatha, in the chat, and since you have some time on your slot, I think you could take it. This is from Adomat. Adomat Gerald is wondering why, I don't know if this is a fair question to you though, but Adomat is wondering why the banks are always reluctant to make good of financial loss by customers, especially in cases where it's glaring that the bank is at fault. And he wonders whether it's always the route that advocates have to go through protracted litigation to be able to get compensated. So Agatha, I don't know if you work in a bank, but it seems an unfair question to you, but please attempt to respond to Gerald.
I think that it's not the general rule that banks do not want to actually make good where they are actually in the wrong. We've seen instances where banks have made good, where actually the loss was as a result of the negligence of either the bank or the bank staff, and there are cases to that effect. So I don't think that's the general rule. There may be some exceptions where bankers they are not trying to not make good, but there are certain obligations that even the customer has actually failed to make good as well. So it's not an issue of they do not want to pay, but they're saying that the customer was actually also negligent in ensuring that this fraudulent action happened. So it's not that lawyers are prolonging the process in litigation, but it's a matter of evidence. If you're saying that your money was fraudulently debited from your account without your consent, it's a matter of evidence. Proof has to be brought, and the bank usually has. There are cases, for example, where this two-factor authentication I talked about is in place, and then a code was sent to a phone number. That phone number actually, the person actually received the code because maybe I didn't talk about SIM swapping, but sometimes it's SIM swapping. But the bank on its part, the two-factor authentication happens. The code is sent to the phone, but on that end, there's a SIM swap, which is now goes back to the responsibility of the customer to safeguard their SIM card and phone to ensure that a third party does not have access. So in that particular instance, the customer will look at it as, but I did not have my phone at the time of the transaction. But on your end, a third party has actually tapped into your side, your obligation on your part to safeguard your phone. So the customer sees that the bank is actually not making good, but on the side of the bank, they have actually followed the internal control security mechanisms that are required. So at the end, it is evidence. So the lawyer is not prolonging, but they are bringing the evidence. There's evidence a code was sent. There's evidence the person received the code and actually put in, and the transaction did happen. So at the end of it all, it's evidence, and the one that brings the evidence, he who alleges must prove. If you fail to do that, then the bank shall not be held liable for where the customer should have protected themselves. Mm-hmm.
Thank you. Thank you, Agatha, for that response. I still see one more question for you just before we go to the next speaker. But you do strike an important point, and as was held by Justice Mubiru, I think it's a responsibility from both ends. The bank and the customer both have to be careful while transacting to make sure that they don't facilitate fraud. But I want you to attempt this one last question before I bring in the next speaker. And this is from Zulaika. Zulaika says she's wondering why internet is a problem to banks in Uganda. I imagine she refers to cases where you go to the ATM and the ATM is not working. You want to do an online transaction and then you don't get to access your bank account, and all these perhaps are caused by internet. So she wonders, why is that a problem for banking industry in Uganda?
Okay. Thanks, Zulaika, for that question. Banks are also users of internet, really. They are not the providers of internet. The providers of internet and the telecom companies. And so just like an individual, you do suffer with your internet connectivity, so do banks. So the ball goes back to who is actually providing the internet service. And on my end, really, I would say that the service provider of internet, the telecom companies, need to ensure that there is continuous internet provision, not just to banks, but all of us. Because personally, yesterday I was trying to transact online on my app, and it kept on telling me that I'm unable to actually transact. So one, the banks need to up their usage. They need to, because we are so many of us using these apps. So if they are going to serve us effectively, they need to invest. I am not very well versed with the internet knowledge, but I know that you need a certain, how do they call it? Yes, a bandwidth. You need a certain bandwidth to accommodate a big usage, a big group usage. So if you're having over, let's say, 1 million people on your app, you cannot have the bandwidth of like an office like this that has 12 people. So if you do not increase your bandwidth, then you will find that your internet connectivity is always having a hiccup because it is being overly used. You're actually straining your bandwidth. So banks need to increase, invest, because really most of us love convenience, and we shall use these online banking apps. We shall use digital services. But if the bandwidth is small, then you have hiccups. But also the ball goes back to the service provider. Provide stable and consistent internet, because we want to transact. I don't know if I've answered that, but I don't think I was the best person to answer that particular question, but I think that I have tried.
Yes, indeed, you have tried to answer the question, Agatha. To be honest, we're all victims of internet. Sometimes you're in locations where the internet speed is not the best. You're trying to attend an online meeting and you keep buffering. So those are realities that I think we have lived with as Ugandans, but as time goes on, as people get more aware, as service providers improve, then those challenges I'm sure will be done away with in time. But allow me now to move on to the next speaker on the program. And the next topic is very exciting because a while ago, as you might recall, there was an amendment in the Financial Institutions Act that introduced what they call now Islamic banking. Islamic banking is a new phenomenon that most of us maybe have heard of but are not so familiar with. But we are lucky to be blessed with the presence of Ian Mutibwa. Ian recently held a training in Islamic banking and has been very keen in following trends in that Islamic banking space. And today, Ian is going to be talking to us about precisely that. Islamic banking, Islamic finance, what are the products that Islamic finance or banking has to offer? And maybe by the end of this conversation, we'll have a fair understanding of what Islamic banking is, what structure does it adopt that is different from the traditional banking that we are accustomed to. So most of these aspects are going to be discussed in this next presentation. So please make welcome to Mr. Ian Mutibwa, who is a partner at Signum Advocates, actually the managing partner at Signum Advocates. Mr. Mutibwa.
Thank you very much. Good morning, dear listeners. I thank the ULS for this opportunity to discuss Islamic finance. I should also add that I'm the current CE of the Islamic Hub, which offers training in Islamic finance. My role today is simple, talk about Islamic finance, but basically looking at taxation, the products, but also taxation of Islamic finance. one of the things that we have experienced the most or had a lot of feedback on is the understanding of Islamic finance, whether it actually does not have interest component in it. And that is where we want to throw more emphasis and maybe emphasize and see how best we can discuss this. One of the things I like to say most is that Islamic finance is on the same commercial terms, different route, but the same destination. So Islamic finance and commercial banking have the same commercial terms, using a different route, but you're going to the same direction. And I will explain that on what that actually means. Islamic finance is not what everyone thinks it is, and most people think, as you see it, Muslim financing, only Muslims can access it. In most jurisdictions, to take away that connotations, I've called it a different name, such as alternative finance or asset-based finance. So it's not particularly say it's only for Muslims, but it's based on pillars of Islam, and that's why it has a connotation of Islamic finance. And I'll just briefly highlight on the pillars of Islam that make the basis for this particular Islamic finance. The first one is what everyone wants to know about, is a prohibition of interest, or what they call riba under Islamic laws. Islamic finance prohibits you charging an interest on a particular transaction, or you getting a benefit or a gain on a particular transaction. That's one of the interests, or one of the pillars of Islamic finance. There is no charging of interest. But I'll expand on that so that you know that it's not extremely 100% no interest, but how does that play around in Islamic finance? The second thing is that Islamic finance is not a financing of chance. So there's certainty, there's no speculation. What that means is that when you agree on a certain amount of money to be paid back, that will be it. There's no speculation, there's no chance on it. Now, interest as we know it floats. When currency fluctuates, interest rates may probably go up. When currency appreciates, interest rates may probably go down. And that creates uncertainty. It creates a little bit of speculation. What will happen to interest rates today or tomorrow? So that prohibition of interest in as far as Islamic finance is concerned is the whole prohibition of charging that particular type of interest, the fluctuating type, where you have today you're not clear, tomorrow you don't know what's going to happen. So it prohibits chance, it prohibits interest per se. It also prohibits certain aspects of the economy that are considered as illegal under Islamic law. For example, gambling, alcohol, pork. So you cannot finance things that they call haram. You've heard of what they call halal foods. So they finance more of halal products and not haram products. So if you're doing a business that has a halal aspect to it, you can apply for Islamic finance. But if you have a business that has a haram product in it, you may not qualify for this type of finance. The other one is the risk. Risk is usually shared between the financier as well as the person who is borrowing or is taking the financing product. So there's a risk sharing approach to it. And the last one, which is the most important, is that the transactions are asset based. They don't have hanging transactions. So there's no lending per se in Islamic finance. It is an asset backed transaction which creates a transaction of financing. So you won't have cash moving between bank or financial institution and the lender. There's always an asset to back up that particular lending. So those pillars are important to understand, and how you're going to transact in Islamic finance. It's important to understand that 1, there's no riba. 2, there's certainty, no speculation. 3, they do not finance haram products or products that are not halal. 4, there's risk sharing. And 5, the transactions are asset based. So there's an underlying asset when you're doing that particular financing. It's important to note that when the FIA was amended in 2016, it created a situation where financial institutions are allowed to own assets. What that means is that a bank financing an Islamic finance can actually purchase a piece of land, own it as a bank, and then lease it to a customer. So the asset will be the land that they've brought. That's the asset that the bank will have and will be leasing it. So it's not a cash to cash transaction. It is the bank owning that asset. Remember that principle of asset based. The bank owns that asset, then it leases that asset or rents out that asset to a customer, either the finance lease or an operating lease. And that goes into the different structuring that you want to have for that Islamic finance product. There are different products that are on the market or Islamic finance, both under the accounts of Islamic finance and also the lending. And there's a speaker going to come and dig a deeper detail in how those products work. But I'll just probably highlight a few of them, and maybe tomorrow at the conference you will also understand and appreciate those products in detail. There's what they call, there are three types of products. There's the leasing product or the lease. There's an equity product or the equity financing. Then there's also the asset-backed product. And all those three have different products under them. You hear of the murabahas, the musharakas, the ijaras, the istinas, the different types of products, and all those play into those broad three perspectives. Asset-based, is it an asset-based leasing or asset-based transaction? Is it a lease or a lease-based transaction? Or is it an equity-based transaction? Remember, the FIA now allows the banks to own property, including shares. So they can actually have an equity-based financing, but also have asset-based, so you can own assets such as land, mobile phones, cars, and things like that. But also the lease-based options, which will be expanded upon as we go along in this particular symposium. But it's important to understand that with the invention of Islamic finance, the dynamics change. Remember, it is the same commercial terms, different route, same destination. What happens when you have a different route? When you have a different route, many things come into perspective. One of the things that you need to look out for is accounting. How do you then account for Islamic finance products which are not ordinarily using the same route as the commercial products? Remember that it's the same commercial terms, so it's you have a contract drafted up, same terms, and everything goes along with that. But the route is being different. The way they're going to structure these particular products will be different. So aspects of accounting come in, and the accountants will tell you that they are what they call the IOFI standards. The IOFI standards are the standards, accounting standards that have been developed for Islamic finance, where the IFRS or the GAAP standards do not provide a particular alternative. So the IOFI standards come in to emphasize and show what other standards can be used to account for Islamic finance. But the most delicate one is a tax. When you look at Islamic finance products, taxation of Islamic finance products created a little bit of a divergency and would more or less create an unfairness in someone getting an Islamic finance product over the commercial lending. And this year, I think 1st July, the Islamic finance laws were introduced into the tax regime. So tax laws were changed to provide for Islamic finance. And the reason why I'm here today is to help you understand and appreciate why that was done and how that impacts on the Islamic finance lending moving forward. We have now a bank, Salam Bank, that has been licensed to carry out Islamic finance product or Islamic finance lending, fully fledged Islamic finance bank. But the law also allows for a commercial bank to have an Islamic window where you can have conventional lending and also Islamic lending in the same financial institution. That can also happen. I know of some products that are being crafted in microfinance, and Microfinance Support Center is doing a lot of Islamic lending. But also I know some money lenders who have created unique products such as lending through technology. That's also happening in Uganda. We've interacted with some of them, and they have very interesting product and how they're going to lend Ugandans using Islamic finance. But the uniqueness of their products is how does then the tax play in those Islamic finance products that they're lending out. Remember, I told you there's asset-based, there's lease-based, and also there's equity-based. So let's take a simple example, a simple asset-based transaction. If the bank is lending in a conventional lending, and someone wants to take a mortgage, they will go to the bank, pay maybe 20% or 30% of the value of the mortgage. Then the bank will lend them money to purchase that property, and they'll pay the bank with interest over a period of 20-25 years. That's a conventional finance. That particular aspect has two or three tax points. The first tax point will be on the transfer of that asset to the new owner, who is a person borrowing from the bank. There will be a 1.5% stamp duty at that point on the transfer. When they're creating the mortgage, then they'll create a 0.5% stamp duty on the creation of the mortgage at the point of mortgage in that particular asset. And then when you're paying back interest to the bank, there is no withholding tax, because you're paying back interest to financial institution. There will also be no VAT, because that transaction is not a vatable transaction, it's a financial institution transaction. So you realize that a lending transaction in a conventional finance will probably have stamp duty 1.5 and 0.5% stamp duty on a lending, creating a mortgage. So you round it off to say 2% on a duty. Let's take that same example to an Islamic finance transaction. Now, an Islamic finance transaction, remember that it has to be asset-based. It being asset-based means that the bank has to own that asset to be able to give that asset to the person who wants to actually own it later. So the first tax point is the bank will have to purchase that asset and own it. The bank owning that asset will have to suffer 1.5% stamp duty on a transfer to the bank names. That's the first tax the bank will have to face. When the bank gets that asset, they'll say they're going to rent to you that asset. So you're going to pay rental on that asset. It's not a profit, it's not an interest, it's a rental. That rental tax, or that rental being paid, means that the bank is now earning rental income tax from that asset. When you're paying rental income tax to a financial institution, there are aspects of VAT, there are aspects of withholding tax, depending on what rent you're going to be paying back. So the bank will have to suffer rental income tax, will have to suffer withholding tax as you're paying back on that rent. Remember, that cost then increases the aspect of the financing for the borrower. The bank now is getting rental income, which ordinarily in a commercial transaction, a commercial bank will not have any rental income. But now they have a rental income that's subject to rental tax, in as far as we know rental income tax is concerned. So this person who's borrowing in a conventional banking is only suffering 2%, but the person who's borrowing in an Islamic finance will suffer 1.5% at the transfer of the bank, because that will be the borrower's cost. Will suffer 15% withholding tax on a rental income tax. Will suffer VAT 18%. The percentage has gone up so high for the person borrowing. And at the point the person finishes renting that asset and they're going to own it, they have to transfer it to their names. Then it becomes another 1.5%. So the tax laws were unfair in that particular respect to a person borrowing in a mortgage transaction for a commercial bank, and then a person getting an asset in an Islamic finance way. So the tax laws had to change. One of the ways it changed is that it defined what interest is. And interest includes rent, includes profit, includes... So the treatment of that interest component for Islamic finance is now the same as you treat a rental payment for borrowing in an Islamic finance product. So you'll find that if I'm paying back rent to a bank which owns an asset, the bank will be exempt from withholding tax because that is a financial transaction. The VAT laws also come in to say when you're lending under Islamic finance, it becomes a financial transaction exempt from VAT under Islamic finance. So that means that at the point of you paying back that rent or paying rent to the bank to own that asset, it will be treated as a financial transaction exempt from VAT. You're going back to the same leveling ground as a commercial borrower. And lastly is stamp duty. If you have an agreement for a sale of an asset under Islamic finance transaction, the stamp duty is exempt for the financial institution. So at the point of the bank owning that asset, there will be no stamp duty payable. What that does, it puts you in the same level as someone borrowing from a conventional bank. The structuring is different. The way that structure is done would differ, but the tax treatment would be the same. So looking at situations where you have had a change in the way that a transaction is structured. And when that change happens, the tax treatment is not impacted or does not impact the borrower greatly. That is in a typical asset-based transaction. We can use the same example for a lease-based transaction where you have a finance lease and an operating lease. It's the same exact thing, because for a lease-based transaction, again, the bank will have to own the asset. Whereas in a finance lease aspect, the bank may not own the asset in its books of accounts. Although accounting standards have changed for it to recognize that asset as your book in your books of accounts, but the same thing would apply. Then you have issues of equity finance, where they say we're going to share in this particular asset as equity partners. We share the interest, we share the loss, we share the profit, we share the loss. When the bank is getting that share of that profit, it will be treated as an interest to the bank, which is exempt from withholding tax because it's a financial transaction. That then brings parity, because tax laws are supposed to be fair, they're supposed to be equal. They're supposed to have equal treatment for those for any transaction happening in an ecosystem. Excise duty was also exempted. Some transactions exempted from excise duty, so that to ensure that someone lending in an Islamic finance way is not prejudiced because of the tax laws. So the tax laws are to change. One of the things that you need to understand about Islamic finance is that it's not a straitjacket kind of lending. What scholars of Islamic finance say is that you need to look at the environment you're lending in, or the environment you're transacting in, and adapt to the customs and cultures of that particular environment. So as Islamic finance develops in Uganda, you're going to realize that things are going to adapt, things are going to change. You will have what they call fatwas. A fatwa is a proclamation on how something should be done. So what happens is, when you have a structure of Islamic finance, you've maybe created a diminishing musharak. A diminishing musharak would be, a musharak is an equity financing. Diminishing means that your share in that asset keeps reducing the more the person pays back a dividend. So I'll give you an example. Let's say we own an asset, project finance asset, a project, we own it 50-50. The bank has 50% share, I have 50% share. I keep paying rent to the bank of a certain amount of money. Whenever I pay that rent or that profit to the bank, their share reduces in that asset. So I pay back, let's say, 20 million, I get 1% back. 40 million, I get 2% back. So their share diminishes. Their musharak, their equity diminishes in that particular transaction. If I'm paying back that equity and it's diminishing in that particular respect, you realize that I'm gaining in an asset, and at some point I'm going to own that asset 100%. The law will require that as I gain, I'm not prejudiced as if someone who is only paying back an interest. Okay, so we need to be clear that these particular aspects of Islamic finance will change over time. They will evolve. We'll see new things happening. So back to the fatwa. When that diminishing musharak happens, you realize that certain conditions in Uganda will have to be fulfilled, and they may be different from conditions in Kenya or in Malaysia or in Saudi Arabia. So the scholars will sit down and say, how then do we structure this particular diminishing musharak to suit Islamic principles, but also the cultures in Uganda? And then a product will be developed specifically for Uganda, and a fatwa will be given that when you have a product diminishing in Uganda, you can structure it in this particular respect. And that's why you have what they call a Sharia board in different financial institutions which are going to conduct Islamic finance. They're going to cross-check those particular products to make sure that, one, they comply with the principles of Islamic finance, but two, they comply with the cultures and the systems that are present in an ecosystem such as Uganda. So it's not a one-size-fits-all, and we're going to see a lot of development, a lot of changes happening to make sure that every product suits what is required under Islamic law. So tax laws have changed. I'm sure business laws will also change, accounting laws will change. You see certain things changing to suit particular products of Islamic finance that are going to be given in Uganda. it is important that you understand and appreciate that this is not Muslim finance. I am not Muslim. I have studied Islamic finance, and I can authoritatively speak on it, although not Muslim. So it's not a Muslim finance, it's alternative finance. It is a way you can finance your business, get to a certain destination, the same way a commercial person would. We've also seen products which have a mix of both commercial and Islamic finance. So they can actually lend in the same exact transaction, where you have a commercial transaction as well as an Islamic finance transaction. So they can work together to achieve a certain end. What these products come to do is, one, to create a little bit of fairness in the market, because I know I have a few clients who could not maybe borrow from commercial banks because of idea of interest. They could not invest in unit trusts because of the idea of interest. They could not invest in treasury bills and bonds because of the idea of interest. Now, with Islamic finance, you have Islamic bonds, which are called the sukuks. You can have Islamic bonds, which have a structure of their own. You can have Islamic accounts, which can give you a fixed deposit of sorts, a profit sharing account, which can give you a fixed deposit of sorts, which will not prejudice you as a person who does not believe in a taking of interest. So, in a nutshell, we realize that Islamic finance is here in Uganda. We have now started operationalizing it. The laws have started to change to allow for Islamic finance, and the laws are going to support the entrenchment of this finance. Technology, tax, accounting, commercial and economic laws are going to change. The law always follows commerce, and the law and Islamic finance is following the commerce of Islamic finance. I thank you.
Thank you very much, Ian, for that elaborate discussion on at least the basics of Islamic financing. I know that our audience out there was listening to words for the very first time, Musharat, Fatwa, but just hang in there because Ian is present for a Q&A session after the last speaker. But just before I go to the next speaker, Ian, it looks like you have a question here. Okay, this is not for your packet, but I just needed to understand. While you were beginning your conversation, you did mention that Sharia law applies in Islamic banking, and indeed most of these unique concepts are Sharia based. So one would wonder what law would be applicable in case there is a dispute. Can someone adduce Sharia law, for instance, as opposed to the Islamic banking regulations? What interplay is there between our traditional laws and then the application of Sharia?
Yeah, thank you very much. As I started, it's the same commercial terms, different route, same destination. Of course, the Sharia law provides for instances of default and the events of default, generally, as you understand them under commercial terms. For example, imagine you get a lending and you have a halal business, and midway you realize halal business does not make sense to you and you start doing haram business. That's an event of default. And an event of default happening means the bank has a right to recall the loan with all the different prescriptions that have been given. But remember also, another aspect is certainty. So you will know exactly if there's a default, what would happen, how would you go about it. So arbitration is not prohibited. So you arbitrate, you can get a third party, a second party to arbitrate. So arbitration is there in under Islamic laws, but they follow it with Islamic principles. How do you then arbitrate? And this principle are not different. You know, you call on to a brother to sit down and mediate. Same exact principle that you have in commercial lending. So the Sharia will come in as far as it will dictate how do you go about something. But once you've documented, an agreement is very important, and the law provides for documentation. How do you go about a default? If there's a default and there's a dispute, how then do we go about it? And the law will provide those particular aspects, and they will be followed in as much as commercial contracts are concerned.
Thank you very much, Ian. You do still have a couple of questions coming in from the chat, and I encourage our audience out there to keep those questions coming The speakers are going to attend to them during their slot if they have time left, or in the Q&A session at the end of the last speaker. And Ian, actually you have one here from Irene. Irene is asking for your opinion on the risks associated with allowing banks to engage in other trades. I imagine here she means the aspect of now that the laws are amended to allow banks to own property and participate in that asset-based Islamic banking model. So she wonders what the risks are with that kind of venture for the financial institutions.
Thank you, Irene. Maybe I need to put a proviso to that particular section. The banks are not allowed to engage in that trade. The banks are allowed to own that asset in as far as they're doing an Islamic finance product. So conventional banks are not allowed to own property. It is only for Islamic finance, and that product has to be specific to what you're going to do. So they will not have competition. I know banks engaging in real estate, for example, will be a lot of competition for the people doing a real estate business. But they are allowed to own an asset in as far as they're doing an Islamic finance product. And remember their fatwas, their particular proclamations on how that asset acquisition will actually play out. So you're safe. The risks are not there. There are risks before tax risks. Of course, there are risks of default. The bank has owned this asset. The person has defaulted. What do they do? But all that is provided for in enforcement mechanisms on how they can dispose of that asset, so that the bank does not get into playing into the commercial spaces. So that is dealt around in that particular respect.
Thank you. I think, Ian, your conversation has sparked has ignited some light in the audience. You do have another question here, and I'll read this verbatim. This is from this is from Irene again, I think. And Irene, this is it's the same Irene. She asks, what is your opinion on competition issues raised by Islamic finance, since the financiers now have an incentive to take over the entire value chain? And she gives an example that where a bank sets up a vehicle leasing and then also handles the asset financing. I'm not sure if you've picked that right, but that's the example she gives. But mostly she wonders about the competition, because true to what you said earlier, it seems that the Islamic banking model, most of the laws and regulations seem to be giving it an edge over traditional banking. I'm sure that must be Irene's worry in this question.
Yeah, thank you, Irene, again. I think drawing from my last explanation, the banks will not amass assets so that they can have vehicle leasing and then you do asset finance. That will not happen. The banks will only acquire an asset that has been requested for by a particular lender or a particular borrower. They will not go into aspects of, can we amass assets and do leasing as we go along? So areas of competition will not come in. But even if they do, I'm sure there's a competition bill, a competition law in the offing, and that will take care of issues of competition when it comes to that. But the financial institutions, in as far as asset ownership is concerned, are not allowed to own assets. Maybe I'll give you a clear example. In the more developed economies, they're what they call commodity dealers. Commodity dealers are the ones who then own the asset upon which a lending or financing can occur. So you find a person who has assets worth maybe steel or gold or copper or whatever it is. Usually they use steel and copper. They say, I have steel worth $20 billion. Someone wants to get a financing, they will go and buy steel from that person. And the purchase of the steel is an asset. Remember, it has to be asset based. So they'll get the steel. So in essence, they're not owning the steel, they're just getting an asset transaction. I'm giving you $1 million, you're going to give me $1.1 million on the basis of a purchase of a steel asset. The bank will not own that asset. Someone else will own the asset. The asset will not even move out of the warehouse at all. But because that's be asset based, it's going to be based on that particular transaction that we are transacting in steel or transacting in copper, and I'm giving you 1.1 to go and get this steel from this particular person and go to pay back $1.2 million. I'll give you an example. And then that will be the movement of asset. So even in a normal financing, the bank will not go and own a bond of cars so they can say we're going to do vehicle financing or vehicle asset financing, right? They will only get the car when the person comes, makes a request for a car. Then the bank will own that car, that specific car. And this person will keep renting that car up until they pay it off. So the issues of competition will not come in this particular respect.
Thank you for that. I think, Irene, your fears have been rested in terms of competition. And let's look forward to what the competition law will provide for in cases like this. Ian, before I let you go, because you had time running up to 11:30, and there's still questions for you, I felt that we should utilize this time with these questions just before you take leave. I have one from Zuleika. Zuleika is wondering how the different interpretations by the Sharia boards are going to be applied in this regard. And she goes on to give an example to say, if a Sharia board interprets a certain transaction one way, and then that same transaction is interpreted differently, perhaps maybe by another Sharia board, if it works that way in terms of precedence, how are those two competing interpretations going to be dealt with once a dispute arises?
Thank you, Zuleika. Again, I'm not Muslim, I need to emphasize this, but I have read extensively on this. Islamic finance is based on two sources. The first one is the Quran. So the principles in the Quran where those particular principles I've highlighted stem from. But the second source is a Sunni. And these are writings that also give credit or give authority to certain principles. So when you have the Quran and the Sunni, the different schools of thought which interpret those two writings differently. And because they interpret them differently, there's a danger of what Zuleika has said of people having the same exact transaction but different interpretations. Incidentally, what happens is what they call forum shopping. So people get to shop, they say, this particular group of people will not accept a product designed this way, whereas this group of people will be okay with it. So when you're designing a product, some people do forum shopping. They say, let's go to, let's say, Malaysia. Malaysia structures these things this way, therefore they'll accept. Saudi Arabia, on the other hand, may not accept it because of A, B, C, D. So you need to appreciate and understand which school of thought would allow a certain product structuring, and the fatwas that have been given, those particular declarations. So you will know that if I do a murabaha in this way, the Sunnis will, or the people who subscribe to a particular school of thought will accept it, and these people will not accept it unless I do this particular change. So the bank will look at that particular transaction and say, are we willing to do that change? What the cost of the change? But remember what I told you is that Islamic finance goes back to the economics of the region. So they'll go to as far as looking at Uganda as a jurisdiction. What would work in Uganda? If that particular thing works in Uganda, what is the cost of implementing it? Will the clients in Uganda accept that cost? And then you will realize that different schools of thought will give their views, and then they'll agree to that. And if there's a dispute, again, the forum shopping may come in, but if you have a particular school of thought and have approved a particular product, chances are that dispute will go to those particular people and they will approve it, or they will decide that dispute in accordance with those particular principles that they've laid out. So yes, I agree there will be an issue of forum shopping that may not be taken away, but you realize that as we develop the Islamic finance further, people will get realized there's probably a Ugandan way of doing things, and the Ugandan way is conformist to the Islamic principles and conformist to the commercial principles, because Islam does not do away with trade as we know it. Trade is encouraged, okay? And if trade is encouraged, then automatically the way people trade in Uganda will be appreciated, and they will go to the route of how the product will be developed. So we're going to see a lot of changes happening, and those will be dealt with as they come.
A lot of changes indeed. And one last one for you, Ian. This is from Chiza Oscar. Chiza asks what the comparative advantage of investing in Islamic banking is to treasury bills and bonds. I imagine Oscar here wonders if it's safer to invest in treasury bills and bonds from an Islamic banking perspective or our traditional banking. Are there any tax advantages in taking either route?
Thank you, Oscar. Maybe to get back to the basics, treasury bills and bonds is a lending to a government, and usually government borrows for projects, government borrows for government works, it borrows for many reasons. So in essence, you are lending government. I've written an article before the Uganda Airlines they bought the Bombardiers and other Boeings here on how the government could finance the airline through a sukuk. Emirates has done it through a sukuk bond. So in essence, you create shares in that asset. Remember, it has to be asset backed. So a treasury bond, generally, as we know it is, you get money, you lend to government does whatever they want to do with that money, and they give you back with an interest less the withholding tax. And that tax is the final tax on that treasury bond and bill. In a sukuk lending, on the other hand, you'll find that there has to be an asset. So you will say, I am lending the government for the asset of the airline. Remember that this particular Islamic bond has to go through the pillars of Islam. No riba, no haram, no, all those things have to be in place. So you cannot borrow to go and finance a factory that's going to produce shoes made out of pig skin. You cannot lend generally. That cannot happen, okay? It has to be specific to a particular lending. So you find that they're lending for a particular asset. That asset is a road, express highway. It's a Ginger Express highway. It's a toll road. It's an airline. It's a hospital. It is specific. And the specificity means that you will know what the government is borrowing for and what you're lending it for. And you'll get a share in that particular asset, and they'll keep paying back with those particular interests, and they will diminish with time. So if you ask what a comparative advantage is that in one, you'll find that I am lending government to do whatever projects they want to do, as long as I get back my money. The other one, I am investing with government for a specific project. So you choose, pick and choose. I'm investing in an airline, I'm investing in a road, I'm investing in this. And that's where your money will be channeled to, and the proceeds will come to pay you back. So my view is that when you lend to government is the best borrower. They always pay back regardless of the regime. You always have a debt with government. It's a sovereign debt. So you will always get your money back. So either way, whether you're doing the Islamic way or the normal way, you'll still get back your money. And maybe I should also add that with the Islamic economies that come in, you'll find that Islamic insurance is also being developed. I know that IRA is now in discussions of doing takaful insurance, which is Islamic insurance. So you'll find that as we do the Islamic products, Islamic insurance comes in to protect those particular products that are going to be floated onto the market. I hope I've answered your question, Oscar.
You did answer Oscar's question, but you do have several others. And to be fair to the audience, because the allocation for you was until 11:30, we still do have a couple of minutes on your slot, and I would want that we utilize those minutes with these different questions coming from the audience. So bear with me a little longer until about 11:30. For those whose questions are not answered during the slot, that simply means they're going to be taken care of in the Q&A. So please keep them coming. Even when the speaker has already gotten off, those questions are going to be answered. So you have one from Brenda Tusime, Mr. Mutiba. And Brenda is indulging your opinion on an operating lease model. And she does say, you mentioned that Islamic financing is asset-based and there has to be an asset. And she wonders if it is an operating lease model, what happens at the end of the lease? Because the financial institution cannot own the asset by buying the residue. So she wonders what happens to that. Does it revert to traditional banking? How does an operating lease work in cases of Islamic banking? And she also asks if there are any accounting principles that are tailor-made for Islamic banking.
Thank you, Brenda. What happens to a lease in an operating lease type of scenario? Incidentally, you will not find many banks lending for operating lease perspectives. They're not so many, because what happens in an operating lease, maybe if I explain further, a finance lease is a lease to own. More or less, the bank purchases the asset, you lease it over a period of time, and then that asset becomes yours. That's a financing lease. An operating lease, on the other hand, is you lease the asset for a particular period, and once you're done leasing that asset, it reverts back to the owner. So you won't find many banks doing operating leases, but some of them will do. Now, in a scenario where there's an operating lease and Islamic finance, you'll find that there will be certainty that at the end of this operating lease, we shall dispose of this asset, and whatever gain we get, we shall share in these particular shares. So they can agree that we shall own the asset, you rent it for a period of 20 years. After 20 years to be sold off, it has depreciated, it has done all these other things. But whatever we sell off, because you've paid back our money, we shall share the proceeds in this particular way. So that the asset does not sit with the bank. But most times, you realize that financials will prefer financing leases because they're not in the business of owning assets. On accounting principles, as I've said, the accounting standards, international financial reporting standards, will apply to Islamic finance in as far as they do not contradict the Islamic principles. Where they contradict, there is a standard called the IOFI standards. IOFI are the Islamic standards that come to explain or support the accounting standards that are already established. So there's an IOFI board that sits. In fact, this morning I was reading about the IOFI standards that have been changed recently. Islamic Financial News has given us a particular interpretation of some standards. What they do, they come in to interpret a standard in line with Islamic finance. Remember, the process starts from creation of the product. When a product is created, the tax incidents are known, the accounting incidents are known, and all those other things are known. Once they're known, the accountant will come in and say, the IFRS does not provide for this particular issue, or the IAS or the GAAP standards don't provide for this issue. What do we do in this particular transaction? Then the IOFI, the board will sit down and say, in that particular transaction, it should be treated this way. And the IOFI standards will be the ones used at that point in time. So yes, accounting standards are there for Islamic finance, and they will keep developing as we move along. But they do not contradict the already established IFRS standards. They just come in to support where there is not clarity in those standards.
Thank you for that response, Ian. And lastly, from Zulaika Steele, she asks, how accessible are these loans in Islamic banking?
How accessible they are. As I said, we have done, as a firm, Signum, we have done lending for diminishing Musharak and Nijara as well, but they were offshore. The offshore lending, because at that time we didn't have an Islamic bank lending. But our clients are increasingly demanding for Islamic finance and accessibility to loans. Salam Bank was licensed about a few months ago, maybe 1 or 2 months ago. I know they're in the process of capacity building and sensitization, but I'm sure come 2024 we shall have active lending from Salam Bank. Deposits will be taken for different accounts, and the accessibility of the loans is there. So in Uganda, it's still nascent. We're still looking at developing that market in Uganda. But around the world, it is very, very vibrant. If you go to Malaysia, if you go to Sri Lanka, you go to Saudi Arabia, the UK as well, there's a very vibrant market on Islamic finance. And people accessing these loans left, right, and center. On how we structure them is a different story, but we are happy to help on structuring and advisory on how that particular transaction is going to go.
All right, there you have it, Zulaika, and that has been Mr. Ian Mutibwa, Managing Partner at Signum Advocates, taking us through Islamic financing, the products, and what we need to know under Islamic banking sector. Now, allow me to move on to the next speaker. And the next speaker is going to be talking about a topic that we are mostly concerned with, especially when you're interacting with banks, transactions, and anything commercial. The next speaker is going to be discussing the key tax considerations in the banking and financial sector. And this is none other than Ms. Anne Kakuba Naziri, who is a tax manager at BDO East Africa. As Anna comes on, please, I would like to remind our audience that you could still keep the questions coming, because there's going to be a Q&A session right after Anna has spoken, and most of the questions that were not attended to during the speaking time for the different speakers are going to be attended to at that time. But also to remind you that we do have another day tomorrow where we also have interesting topics for discussion. So please do again join us tomorrow using the same link. We will be entertaining a lot of your questions, especially because we have two Q&A sessions in the tomorrow's event. So today has been our first event, our first day for the program, but we also do have day 2 tomorrow, so do remember to log in, and most of what has not been talked about in today's program is going to be covered in the next program. And also remember that this is the banking law sector, rather the banking law cluster under the Uganda Law Society, and the banking law cluster is among the many clusters that operate under the Uganda Law Society. We do hold these kind of symposiums on an annual basis. This is one for 2023, so we'll be looking forward to hosting you again for the next banking law symposium the coming year. Without wasting any further time, I would like to now request Ms. Anna Kakuba Naziri, tax manager at BDO East Africa, to take us through the key tax considerations in the banking and finance sector.
All right, good morning, everyone. So today we're also going to talk about the key considerations when it comes to taxation of the banking sector, as well as other microfinance institutions or microfinance deposit-taking institutions. We're going to go through the overview of taxation of banks, and we're going to look into tax heads such as income tax. We're going to look at transfer pricing considerations. We're going to look at tax treaty applications. We're going to look at withholding tax, excise duty, and VAT, as well as tax risk management for banks. So to start off, as we all know, the financial services sector is one that is highly regulated. They're regulated by BOU, they're regulated, the MFIs and the MDIs are also regulated by their own regulator. So for them to be compliant, it's not just to be compliant with just those regulators, but also to be compliant with URA as well. And given that these institutions are dealing in high value and large transactions, you will notice that it brings about an issue of exposure. Their tax risks are much higher because of the value of their transactions. And as we can all see in the current circumstances, URA is really interested in collections. So what is happening, we're seeing more disputes happening because of the way URA is applying certain sections of the various acts. And given that banks, because of the nature of their operations, they have a lot of tax sets that they have to be in compliance with. So we'll now just delve into the different tax heads to see what key considerations banks need to look into. So to start off, we have income tax, and this is where banks have to pay corporation tax of 30%. And some of the key sections that we're seeing URA overzealously applying regulation are around section 47, which deals with interest that's subject to withholding tax. So ordinarily, if you have discounted interest or deferred interest, URA will treat it as paid only if you have accounted for withholding tax and if you've actually paid that interest. So they'll look at your withholding tax returns to see whether you've withheld on that interest that's subject to withholding tax. And the way they're treating it is that if I have unpaid interest for, say, 2023, and then I pay it in 2024, what URA treats as deferred interest is your unpaid interest as at the end of 2023, which is quite different from the meaning of deferred interest for banks. Because what banks treat as deferred interest, I'll give you an example of a transaction that deals with deferred interest. So what happens is, say if I buy an iPhone and I'm buying it in installments. So what will happen is the vendor will probably say, if you pay your installments within 3 months, then we will not charge you interest. However, if you pay within installments above the 3 months, then the interest that we would have charged you in the first 3 months will be charged in the 4th month going forward. Now, banks currently do not engage in contracts of that nature, and so for them, their understanding is they do not have deferred interest, whereas URA, like I earlier mentioned, is treating deferred interest as unpaid accrued interest. And what happens is when it finds this interest that is unpaid but subject to withholding tax, it treats it as not incurred in that period. And as we all know, for corporation tax purposes, you're required to get your income, less it by the allowable deductions, and then what you get is your chargeable income. So if you're taking the deduction for that unpaid interest, URA is having a problem with it. It's applied this to one player, but I think because of the back and forth, this review has been put on hold, though it's key for the banks to know. Then in terms of bad debts, around provisioning, there are issues around provisioning as per IFRS versus BOU. So BOU has its separate regulations around provisioning of bad debts, and for purposes of section 25, BOU has something called a general provision, which is 1% of your total outstanding credit facilities. Now that is not tax deductible. However, what URA, especially the team on 7th floor, is noticing is that banks are only focusing on the IFRS provision, and they're not taking into account the provision as per BOU regulations, which is also a low-hanging fruit for them to collect tax. Then in terms of interest capping, whereas banks have been exempted from the interest capping rules of section 25(3), you will notice that for microfinance institutions, that's tier 4, and the deposit-taking microfinance institutions, these have been only brought into the exemption as at July 2023, 1st July 2023. Now what we are seeing is URA is going back in time, given that the change to section 25 came in 2018. Most banks have a December year end, so the application started 1st Jan 2019. So we are seeing reviews for microfinance institutions. These are the tier 4 kind, and we're seeing reviews for the period 2019 to 2022. And URA is saying for that period, you are not part of the financial institutions that were exempted from capping your interest. What's important to note is there seems to be a difference between the understanding of a financial institution as per the Income Tax Act between URA and these tier 4 institutions, because URA seems to be silent on the third option of receiving funds from the public, which is through receiving funds generally, because there's receiving funds from the public, there's receiving funds from members, like SACCOs do, and then there's also receiving funds through debt instruments. Now, you'll notice that a lot of Tier 4 players get a lot of funding through loans and through various debt securities. And that's the part where URA is saying that they're not in agreement, that if that's how you receive your funds, that you're part of the financial institutions. So there's a bit of a tug of war there. And we hope that Tier 4 institutions will take this up with their association and the regulator to take this battle on with URA, because it's going to be quite a bill if they're saying that you're overstating your interest from 2019 to 2022. Then the next issue is around transfer pricing considerations. This is in line also with the transfer pricing rules that we'll see within the Income Tax Act, the regulations that came out in 2011, which any entity that is having any related party transactions has to make sure that the transactions are within arm's length. Now, we have to note that given that some banks are foreign owned, they definitely pay they pay their shareholders, they make payments to other subsidiaries within the group. And what URA is now focusing on is not just about the transaction being at arm's length. It's actually now looking at benefit tests and whether these services actually happen. So you'll notice that they have, within their financials, they have management services. And these management services could include finance and accounting, legal. You have someone helping the HR team locally. You have someone who's supporting the IT team locally. And there are various expenses that are charged to the local entities. So URA right now is focusing on some of these aspects that you can also check from Chapter 7 of the OECD guidelines. And some of these are shareholder activities. So when you say you have an intra-group service, and these are usually under the management services, URA is trying to check for things like the expenses that relate to the shareholder meeting their obligations in their country. So things like consolidation of financial statements, things like where there are external communications to investors of a parent, where there is parent listing on the stock exchange. It's very hard for the Ugandan entity to explain how these activities actually benefit them, because the main beneficiary of these activities is actually the shareholder and not the subsidiary. Then things like incidental benefits. So you'll find that, for example, a bank in jurisdiction A has a high credit score, and maybe being the main shareholder of the subsidiary is also getting a high credit score just because it's part of the group. Now, the test here is to check whether this is a passive association or an active promotion of group members. And where there's passive association, URA does not believe that there is any benefit being given to the subsidiary. The other thing is around benefit tests, where they're testing for commercial value. And here what happens, if there is lack of commercial value, the Commissioner General is allowed to recharacterize your transaction. So here they look at things like, would the Ugandan entity be willing to pay a third party for that said support that you're paying your group different subsidiaries for? So that's the benefit test. And around duplication of services, one of the funniest tests was URA went to a client. The client on their LinkedIn has all these certifications, SCCA, CPA, all the certifications you can think about. But when it came to routine financial services, you'd find that it was someone in the group who was providing these services. So the question was, you who has all these SCCAs and CPAs and whatnot, what exactly are you doing? And why is it that the group has to support you in a role that seems quite simple enough for you to do? So then it was noted that there was a duplication of services. So whereas someone here is doing a part of financial reporting, someone at group also seems to be doing that financial reporting, which is the same. So services like that are usually disallowed. Then documentary evidence. So when you go and do interviews for transfer pricing, someone in the local entity will tell you, receive this support from group. But when you ask them for what kind of evidence they have, this support is not there. So you look at things like where someone says that I receive review support for maybe my reports, but you notice that when the person sends the reports, there is no feedback, there is no notes on how to change XYZ. It's just like the person just sends the report and that's it. So things like that are also key for the TP team at URA. Then allocation keys. This one I'll give an example. So you'll find that, for example, an entity is receiving certain services and maybe they don't receive those services on a yearly basis. They probably receive them once, maybe every 3 years. Every 3 years. And you'll notice that across the group, a number of subsidiaries receive these services, but you'll find that some services require more support. Some subsidiaries require more support than others. Now, if you split that cost on number of subsidiaries, it's not a fair way of allocating the costs. Because, for example, if Uganda hasn't received that service, why is Uganda absorbing that cost? Then we'll move on to double tax treaty applications. As we are aware, Uganda has a number of double tax treaties with various countries such as Netherlands, India, UK, and South Africa, Mauritius. So what happens with these double tax treaties to allow increase of trade within these partners, we try to reduce or to provide tax benefits to the people who are engaging in agreements between these two countries. So one of the things that we've seen with double tax treaty application is contrast between beneficial ownership in the Income Tax Act and double tax treaties, for example, the Netherlands Treaty. So as we've seen beneficial ownership being defined over time, URA at this point wants to lift the corporate veil to find out who the natural persons are behind the entities that are claiming treaty benefits. But you'll also notice that DTS, for example, Netherlands, refers to a beneficial owner as a company. So you'll find that when you look at the OECD guidelines and the reports that are generated by the OECD team, you'll notice that the way we apply beneficial ownership for purposes of our domestic law is actually applied for exchange of information rules. So they do not want there to be a mix-up between beneficial ownership for exchange of information and beneficial ownership for purposes of applying the DTAs. But right now, URA is quite overzealous on this issue, and we're seeing a number of disputes coming up where companies are taking on treaty benefits, yet you'll find that the actual natural persons behind the entities are not necessarily residents to the contracting party states. So this is an issue that has come out. We note that, of course, where the DTA and the Income Tax Act are conflicting each other, usually the DTA is supposed to take to supersede the Income Tax Act. But currently, URA is not accepting that, and we're seeing that also coming through the renegotiation of DTAs, especially with Mauritius and Netherlands, because Uganda feels that through these DTAs, they've actually lost a lot of revenue because of the way the DTAs are structured. The Mauritian negotiation is at the tail end. That one is waiting for ratification. However, Netherlands is still a bit of a tug of war. Then the other thing to note is that whereas there are these reduced rates that are being applied to dividend, to interest, and all these other payments, you have to also satisfy the beneficial ownership tests, like we've talked about, and also economic substance tests. What we're noticing is Mauritius is quick to give any entity a tax residence certificate, but URA is aware of that. So the question is, that entity in Mauritius, does it actually have any economic substance For example, does it have employees? Does it have an address? Is there an actual office? Do they have financials? Are there actual operations of that entity? Or it's a small office somewhere, it's just one person, wherever he sits, it's okay, he can just have financials and some documentation to show that he operates there. But when you actually go into the nitty-gritty, you find that there's no company in that's set up with actual operations within Mauritius. So those are the economic substance tests. They are not defined by the Act, but some of the issues I've mentioned usually come up in discussions with URA. So under withholding tax, one of the key aspects to look at are the fees paid to MasterCard and Visa. So in Uganda, we haven't really seen URA applying this. However, we note that the way URA works, if something is happening in Kenya or Tanzania, URA is alert. And usually the way banks understand their transactions is across the board. So in Kenya, there's a case right now that's being taken to be heard also by the Supreme Court, where ABSA was refuting that the payments that have been made to MasterCard and Visa are royalties, because KRA is recharacterizing these payments as royalties and subjecting them to withholding tax and reverse VAT. Now, we also have banks in Uganda that make payments to MasterCard and Visa, and some of them may not be applying withholding tax. So it's something for them to be aware of, because in Kenya, it looks like their counterparts are losing this case. Then in terms of recomputation of interest paid, given that the discussion on Section 47 has died down, URA now wants to look at it from the other angle, where it's withholding tax and not looking at it from the corporation tax side. So what they're trying to do is to see your closing payable for interest that's payable, whether it ties to the closing payable you would receive from opening payable, the opening unpaid interest, that's the interest that was payable at the end of the prior year. Then you add the interest expense. Then you take out the interest, of course, that's relating to financial institutions, because that one is not subject to withholding tax. And then you take out the interest that is subject to withholding tax that you've actually paid and accounted for in the withholding tax returns. If your payables do not match, URA is quick to say that that difference relates to interest that was paid but not accounted for withholding tax. The other issue is around withholding tax on mortgage property, where we saw TAT ruling that where there are foreclosures, withholding tax should apply on that sale. And later, the higher courts ruled that withholding tax would not be applicable, because the bank is not actually selling, it's just trying to recover its principal and interest. So this is something that we need to take note of. And also because URA sometimes, whereas these cases come out, URA still comes and shakes the banks a little bit to see if they can still get some money out of them. The other is on nostro accounts. So nostro accounts are generally banks open up accounts in other jurisdictions in foreign denominated currencies, and they earn interest, so they pay interest or they pay charges related to maintaining those accounts. So URA is noticing these expenses sitting in the side of the local banks, but they're not seeing the withholding tax, and URA is saying that you're paying a non-resident, and as such, we should receive the withholding tax of 15% on these payments. The other issues, that's 5 and 6, are related to the way banks file their withholding tax returns. We are seeing a tug of war between corporate clients and these banks. Corporate clients tend to fix their money with banks, or they have whichever bank deposit they have with that bank, and they receive interest. Now that interest is subjected to withholding tax, and that tax is creditable for the clients. But at the point of filing these returns, you will notice that a client has interest from bank deposits, but they do not have the tax credit certificates. And when they engage the banks, you'll notice that the banks take too long. And the reason why this is happening is because banks do not file their returns correctly. You'll find that they're missing out things like TINs. And the problem with not putting a TIN in your withholding tax return, it creates an issue where the person who you are paying that interest to cannot generate their tax credit certificate. This has been cured by the recent campaign by URA to make sure that we are all putting the TINs within the withholding tax returns. But we also notice that currently a number of banks are also going back in time to amend those returns that they had filed erroneously. The same thing when it comes to rent paid to landlords. If you categorize that rent as a local supply instead of rent, it sits on the income tax ledger of the landlord and not the income tax rental ledger. So what happens is when the landlord is trying to claim that withholding tax, one, URA will believe that they have another source of income, which is business income, and they will start auditing them on that front. But then two, they are not able to utilize those credits, which again is time wasting for banks because the bank is then required to amend the returns. And usually, as we know, withholding tax is a monthly tax. So imagine sitting there to amend close to 30 months of withholding tax returns. Then under value added tax and excise duty, the VAT considerations that we're seeing are around finance lease arrangements. Of course, because of the way the second schedule is, provision of financial services is exempt from VAT. However, you notice that a bank will go into a different service line, which is asset financing, which takes on the form of a finance lease for purposes of VAT. And finance lease arrangements, as well as hire purchase arrangements, are not exempt from VAT. So if the installments that you're receiving for an asset that you're financing are meeting the threshold of 150 million, which is the registration threshold, or the quarterly threshold of 37.5 million, you're required to register for VAT. And so some banks may not know this, or they know this and they may not be complying with it. And URA is taking a keen look into this because, as we all know, interest on unpaid VAT is compounded and it's not simple interest. So you can imagine how heavy the interest would be if you're not in compliance. Then disposal of assets. When you dispose of assets, we see banks in the newspapers telling us they're disposing off of so many assets. If again you meet the registration requirements, you're supposed the registration threshold, you're required to register for VAT and remit the VAT to URA. Custodial services are also not exempt from VAT, and this is expressly written within the second schedule. So if you're providing these services and you're meeting the threshold for registration, again, you're required to register. Now, there is an issue around imported services that were received between July 2021 and June 2022, where the Act had been amended to say that if you're receiving services but you are providing an exempt service, then that service that you have imported is not subject to reverse VAT. However, this has since been repealed, and now Section 22 requires you to actually remit reverse VAT, even if you're providing a financial service which is exempt. Then the other issue is around VAT burden on foreclosure sales. So before URA was saying that banks are selling these properties to recover their income where the borrower has defaulted, and as such, given that they were meeting the threshold, they were taking this as a taxable supply and subjecting it to VAT. They did not succeed to get that VAT out of the banks. However, that has been since cured by the 2023 amendment, where if a bank uses the services of an auctioneer, then that sale is subject to VAT. So it's making foreclosure sales a bit more expensive. Now, in terms of excise duty considerations, what we have seen in practice is that the banks are asking whether commissions form part of ledger fees, transaction or non-transaction charges, because those are the ones that are charged excise duty. So commissions such as commissions to MoneyGram, commissions to from Western Union, they're trying to understand if those form part of transaction or non-transaction charges, and URA is saying that they are transaction charges and they should be forming part of the excisable commissions and fees, which of course the banks are not in agreement with. Then of course, given that banks have to remain relevant in the environment that they operate in, they always have new service offerings. And what we notice is that sometimes the service offering may have a component of credit or non-credit. And of course, for excise duty considerations, you have to look at the non-credit related service offerings, because if they have charges against them, then that income is subject to excise duty. So banks need to be very, very clear on that when they're coming up with a service offering, to check with their tax advisors on what implications are there. Because again, like for VAT, if you do not pay your excise duty in time, it has the same effect. The interest is compounded. It's not simple interest. Then stamp duty, the banks are waiting very eagerly to see what comes out of the current engagement of Stanbic versus URA. So previously, they had something called indemnity bonds, but they also had bid bonds. And there was a distinction that was made where bid bonds do not form part of indemnity bonds, because the way they are set up, they do not indemnify any party. So those were then later charged the 15,000. Now for the indemnity bonds, of course, those at that time were supposed to be charged 1%, but banks were not charging the 1%. This has since been changed to 100,000, because of course the banks stated the issues that arise from charging 1%. It would make the business quite expensive. However, given that the law at that time required 1% to be remitted, 1% of the value to be remitted, they are in court right now and hoping that the court will favor them and this will be cured. So that case is still in the courts, and we're all waiting to see what the outcome is on whether the indemnity bonds at the time, where they were at 1%, will be charged the 1% or the 15,000. But right now they're 100,000. Now, lastly, the other issue for the banks to note is around tax risk management. As we know, banks are also highly automated. And some of the things that we've noticed is that because of automation, it's also easy for the system not to be updated where there are some amendments to the law. So we propose that you have annual reviews. We propose that you also tell the clients to also look into the annual tax law amendments, because one of the things we noticed is, for example, excise duty, when there were amendments to the rates, you'd find that some banks were still applying the older rates. And again, like I said, excise duty and VAT, the interest component being compounded, can be quite a deal. Then reconciliation workings, and this even cuts across financial sector. It even goes to other sectors. Usually, when players are filing their returns, they usually get the information straight from the system. They do not do any reconciliation workings. And the first thing URA is doing is to reconcile your financials with the payroll costs, with your sales for VAT, with your fees that are subject to excise. Those are some of the quick wins for URA. So reconciliations have to be maintained. Then in terms of documentation, like we spoke about the evidence for related party support, are you actually receiving that support, and how can you support that receipt of that support? That's only through documentation. But also these days, URA does not want to break its head trying to interpret sections. There are quick wins for them, such as what documents you have to support the expenses that you're claiming within your income tax returns. So you'll find that taxpayers, for expenses that you'd expect that they have these invoices, even legal support, that the client can provide the legal support, and then it's, even though they actually receive the support, now that expense is being disallowed for tax purposes. So it's something to think through our record keeping practices. Then agency notices. So these agency notices are notices that are sent to a person who might be holding the money or who's owed money by a taxpayer who URA is now saying, okay, you know what, I want you to make payments for your tax liability. I have tried to get in touch with you to get this tax liability and you're not, so I'm going to go to your bank to get that money. Now, there has to be a balance between maintaining your customer relationships as well as meeting the obligations with URA. So usually on those agency notices, they'll give you the timelines within which the tax is to be paid. So the way you manage your discussion with the customer to make sure that, one, they do not take the money out as you're discussing with them, but also to let them know that you're required to make payments once URA sends these agency notices. And for banks, it's quite important to take this very seriously, because if you do not abide by the agency notice, then the commissioner can actually pass on that liability to you, the bank. And only if you check the taxpayer's account and maybe the money is not enough, then you're also required to inform the commissioner. But if you do not do any of that and you keep quiet, then the liability becomes yours. Then involving consultants, there's so many things. The contracts need to be reviewed by the legal consultants, the tax implications need to be reviewed by the people who practice tax. And then where there are contentious transactions and you're not quite sure what to do, it's also important to seek private rulings, because if you do not comply with the tax law because you're not sure, URA will not have mercy. They'll not say, oh, they weren't sure, let's leave it at that. So that needs to be taken into account. Then the automatic information exchange rules, the act has been passed. Now here, URA may come asking specific information about a taxpayer, which is financial information. It's important to speak to clients to let them know that now you would be bound by that, and that the bank is required to provide this information to URA, of course, while maintaining data protection and all that. Then annual trainings, because again, like we've seen, the acts are amended on an annual basis. So annual trainings to make sure that staff who are charged with tax-related assignments are kept up to date. And then review of procurement processes. We think that this is something that a bank should know, but you find that URA can actually get money from banks through simple things such as withholding tax on payments to local suppliers. But it's because the bank is not making sure that it can track the contracts with this supplier. Maybe the payments are being staggered and the bank is saying the payment was below 1 million, but when you actually look at the contract value, it's over 1 million. So simple things like that may seem a bit obvious, but we find that the procurement processes sometimes create tax risks for banks. Same thing for customs related processes. Banks are not the hugest importers, but when they do, sometimes they import very high value assets. And sometimes if they're not careful, they could lose a lot of tax through the customs clearance if they're not up to date with what to do. And then lastly, tax governance, where the board and people who are charged with running the entity need to understand that given the volumes that they're dealing with, tax is supposed to be a priority for them. It's something that they should look into very seriously and know that at the end of the day, a bank could easily close if it's just getting high penalties and high tax bills and just focusing on tax, yet they have other operations to run. And with that, I close my presentation.
Thank you very much, Ms. Anna Kakuba, for that very technical discussion on tax related issues in the financial institution sector. I was hoping to get some few questions for you from the audience, just because you have a couple of minutes on your slot, but there seems not to be any yet. I'm sure one would come from the panelists. I knew Ian was going to come up with a question, being a tax practitioner. So Ian, you could shoot your question.
Yeah, thank you. Mine is, I hope you can hear. Mine is simple.
Let's just move the mic.
It's also simple. The issue of withholding on disbursements, especially where the cost is not ascertained by the bank. I know the banks are increasingly withholding on disbursements, but most times the disbursements are pass-through costs. It's end-to-end. And then when they withhold, then it becomes a shortage for the business, which you have to top up. But then also it reflects as an income because they give a certificate. Then the URI will think that's an income. So should they withhold? The banks withhold. But then two, how different is that disbursement from a reimbursement of costs? And if they withhold a disbursement, should they charge VAT on it? I hope.
All right, thank you, Ian. So there's been a lot of discussion around disbursements, and one of the main issues that we see and why sometimes people end up having to withhold or charging VAT on disbursements is the fact that, one, if you do not provide me with a document to show me that this is the cost you actually incurred, then it becomes hard for me to explain to URA that I did not withhold because this was a cost that was just passed through. So the issue is also around documentation. So for example, I'll give an example of, say, BDO. If BDO has charged you for certain services that have been provided, and then we include disbursements. So if I cannot support them with documentation, say I paid supplier X for this, but I'm passing on this charge to you, then it becomes a bit hard for someone to say that tax should not be applied on that because I don't have the documentation. And when URA comes, they just sing the song called documentation. So it becomes very imperative for anyone who is dealing with disbursements to ask for support for those disbursements. And that is why tax is usually charged on them. And then if it's a reimbursement of cost, obviously, again, it comes down to what documentation supports that reimbursement. Because again, URA's focus when it comes to disbursements is that you should have that invoice from the third party before they can accept it to not be charged tax.
Thank you very much, Ms. Anna. As like I said earlier, for our audience, please keep those questions coming. I know that there is a couple of questions that were going to the previous speakers, Mr. Musumba and Madam Nakayenga. I know your questions were going to a previous speaker. We're going to attend to those shortly. We just now seek to utilize Ms. Anna's time before she takes leave. Finally, you have a question from the audience, Ms. Anna, and this is from Isingoma. Isingoma asks how realistic he calls it a third-party notice, but I imagine he means the agency notice. How realistic is the agency notice vis-a-vis confidentiality issue with the banks?
Okay, so with third-party notices, ideally what is happening is I'm sending the third party, and it's not only just banks, it could also be your the people who are supposed to pay you. So for example, if you're a landlord, they could send the agency notice to your tenants to recover that money. So what happens, the only transaction that's happening with a third party is I'm sending you the bill of your taxpayer, and then you have to remit that money. If that's if the taxpayer's account actually has that money on that account. The issue that I see with confidentiality is coming from automatic exchange of information rules, because we do not know what particular financial information URA may require, and yet the bank will be bound to provide that information. So that is where we are seeing a bit of confidentiality issues coming from the automatic information exchange rules. But from the third party notices, usually, if the bank can write to the commissioner and say, we've checked this account does not have this money, and you let them know what the issues are, then URA can then devise other means. Like I've said, they would go to the customers of that client and then get that money out of them. But they usually expect that the banks have the taxpayers' money. But if you do not say anything, again, like I said, then the liability becomes for the bank.
Thank you for that clarification. Actually, especially on that point of confidentiality, I remember a while ago, while I still used to work for the bank, URA came up with a request for information about the bank's customers. It was an overarching request that required banks to submit every information they had, the account balances of their customers. I remember banks through the UBA put up a protest, said maybe that's not where you would want to go out to seek information, especially regarding the Data Privacy and Protection Act. And I remember by then the preference was that URA specifies the particular customer and whatever information they need. Of course, they were drawing their powers under the Tax Procedure Code Act at the moment, and like Ms. Anna says, they have those powers to seek for this information. And with these new rules that came out on information exchange, we yet to see what that will be with the balance between data privacy, but let's hope that there's going to be a careful balance. Ms. Anna, before I let you go, I actually have a question of my own. In my experience as an advocate, one of our clients, they had the challenge you talked about where most of their customers, they're into rental business. Most of their customers were banks, and some of these banks would, I would call it misposting. They're withholding tax. They would classify it as a supply of a service, something like that, and then they would post the money in the income tax side instead of the rental side. And eventually that would create a liability on my client's side because they would be reflecting as they have paid inadequate tax to the authorities. So eventually there is a liability in terms of interest from URA's side. And my question is, and maybe this as a lawyer, who bears that burden of that interest? Certainly not the client's fault that there was a misposting on the other end, but that misposting has caused a liability this side. So you face an interest from URA as a penalty for you not having remitted the tax due. So how do you handle those conflicts?
So we actually did have a client who had that same issue, and through the ledger reconciliation process, what happened is it was noted that there was an error to begin with, and the client was not earning any other income aside from rental income. So again, like I said, what happened is they had to go back to the banks. Then the banks had to amend several returns for a long period of time, because they had to open up the system to even go past the 3 years that usually you can amend your returns, so that those banks correct that issue. And it took a while, because again, as we know, the system can be unstable, then you have other things to do. So that process took a while, but the interest was then later reversed because it was noted that the client did not have any other additional income. And even this could be checked with the financials. So again, that whole misposting unfortunately creates issues not only for the landlord but also the tenants, because everybody now starts getting into a wasting time situation. So it's best right from the get-go for the posting to be done correctly, but they would not be charged interest for the error of someone else. Yeah.
Thank you back. Thank you very much for that clarity. We do still have a couple of minutes on your slot, and I was hoping that the audience can chip in with a couple of questions, but we'll be picking them up as and when they come. But you did talk about transfer pricing, and I know now that a couple of banks are restructuring into a group setting where you have a couple of subsidiaries under one holding company. And because it's a structure that is literally starting up, you tend to have shared resources, especially human capital. You have someone working under one subsidiary 2, subsidiary 3. And of course, those subsidiaries being separate legal entities have to file returns. And how do you deal with that kind of situation? Do you now, for instance, if you're paying that particular human resource, do you categorize that as payee in subsidiary A, subsidiary B, and subsidiary C? How exactly do you deal with transfer pricing regulations when it comes to a group structure where resources are shared?
So the OECD also is cognizant of that kind of operation, and if you check Chapter 7, it talks about intra-group services, because they understand that for efficiency purposes, it's not going to make sense to get a one earner on board when internally we have a tax person who understands the way tax works within that jurisdiction. So they are cognizant of that, and usually those fees are charged through management services. But again, like I said, there are issues around allocation of those costs, because, for example, if another group tax person has not provided any services to Uganda because maybe Uganda did not have any need for the tax support, URA does not expect to see a cost relating to tax support. But where I have provided the support, again, it comes down to, was the support needed? Was I charged at arm's length? So the question will be, if they looked at another entity that is receiving these particular services and we're operating within the same jurisdiction, the same kind of operations, would they pay that same amount? So the shared services usually come through the management services. But then again, the benefit tests have to be carried out. You have to check whether those expenses are at arm's length. And then you have to check for the documents that evidence the support being provided. Because it's not enough to say that we had financing support when they look through the financing information, everything was done by the Ugandan entity without any support from another subsidiary or the parent entity. So, yeah.
Thank you very much once again, Ms. Anna Kakuba, for that kind of very, very technical conversation indeed. I think the debate that taxation is 70% accounting and 30% law, maybe is the reason why we're not 70% law. I think I get a correction from Ian, 70% law and 30% accounting. But thank you indeed very much for that. And I'll revert now back to the questions that were raised earlier by our audience. I have a question here from Nakayenge Marion, and this was going to Mr. Parteka, who presented about sustainability in the financial sector. And it relates to your conversation, Mr. Parteka, about the sustainability standards and certification initiative that was recently launched by the Bank of Uganda. And Marion seeks to inquire if what is the cost of the certification, and is this certification renewed annually? Just help me get.
Thank you. So, to answer that question, this is a voluntary setup. These are international standards where banks apply voluntarily to be certified sustainably. So they are reviewed annually, and I think you've seen with the UDB going for those reviews annually. So yes, the cost, I may not put a cost to it because it is voluntary. Yeah.
Okay, thank you. I think Mario Nakayenge, you got your answer. But Mr. Pateka, you do have another question here from the Q&A. And this is from Mr. Musumba Martina. I hope this is a it's a girl, it's a lady. Apologies, Miss Musumba Martina. And the question is that please elaborate the effectiveness of the SSCI on human capital as part of the Octagon 8 value chain model for a bank to qualify for the SSCI certification. I'll repeat that. She says, please elaborate the effectiveness of the SSCI on human capital as part of the Octagon 8 value chain model for a bank to qualify for this certification.
So the emphasis with SSI on human capital is basically on training of staff and making them comfortable to work for that institution, thereby creating sustainability of the institution. So the institution should rely on the experience of this staff to grow from one stage to another. You don't want a staff to come today and the next month he or she is leaving. Okay? So how does the financial institution train that staff, and how does the financial institution retain that staff? What sort of activities can the financial institution put in place to retain such a resource? So basically, SSI is looking at the retaining of the staff so that that staff can contribute to the growth of the institution, thereby leading to sustainability.
Thank you very much, Mr. Patek. And maybe before we leave the Sustainability Standards and Certification Initiative, I know that a couple of banks have signed up. I know Postbank, for instance, has signed up. I don't know what your estimation is for the industry and how banks are responding to these certification standards, and if indeed a couple of more banks have signed up for this.
So far, from the statistics, I think we have like 5 banks. We have UDB, Housing Finance, Postbank, the regulator, Bank of Uganda. And I think more are going to come up, but this being a new initiative, I think some banks are still standing it, but I think more will be joining soon.
Thank you very much, Mr. Pateka. We still do encourage our audience to participate because this is your segment, the Q&A, where you seek clarity on the different topics that have been discussed. Your questions are going to be read out to the speakers and then they will respond to you instantly. But do remember that we do have another session tomorrow where you can still seek clarity in case you haven't gained that clarity in this session. I just needed to bring back Miss Agatha Nisima, who presented to us about the legal dimensions in electronic fraud and how we can protect the financial system. There's been a lot of identity theft. You have a lot of fake online profiles. You have fake recruitments. There's a time, I think, there was a complaint in the public that someone was recruiting different employees for different roles, but this was a scam. So people create identities online and seek to fraudulently benefit from them. I don't know to what extent the Data Privacy and Protection Act can control that kind of situation, but in your experience, what do you think the law specifically has to offer in terms of identity theft?
Thank you for that question. I just want to go back to the need for all of us to be vigilant, really, don't take information at face value. Verify, first of all, if you get anything being said about something. If someone says they are recruiting, please seek clarification, verification from the company itself. Because usually these schemes, the email address or the phone number that's there is belonging to an individual. So please let us be vigilant, seek to verify any information that that comes out there, because for now there is not much that is being done to actually curb identity theft. But if you're found liable, there would be really it would be impersonation, and you can be held liable under that. But it goes back to each one of us being vigilant to ensure that you verify information. If someone calls you and is saying you have been offered a job opportunity you never applied for, why would you be in a hurry to accept? Because I think there's this online scam where you receive an email saying there's someone who has an estate in a certain country and they want to, to share the proceeds from an inheritance. So share your bank details. If someone you do not know shares such information, why would you be in a hurry to share in an inheritance that you have no idea about? So I think we need to be vigilant and not to, run for free things, like I said earlier.
Thank you, Agatha. But just before we leave that specific aspect, because most of these are actually cross-border.
Yes.
So you have someone seated somewhere, or even if they're not seated anywhere, they by some means locate themselves into some place that is not here in Uganda, but when the action is really happening here in Uganda. So how do you deal with that cross-border aspect of those kind of that kind of fraud? Has the law been able to address it? Have you seen successful prosecution in terms of cross-border crime, and what nature of evidence? How does that turn out in cases of cross-border fraud?
I think as a country, we need to collaborate with other countries in terms of curbing cross-border fraud. I know that the police, in trying to handle some of these fraudulent activities, have tried to trace. They try to trace, but then there's always a dead end if it's a cross-border fraudulent transaction. So, as a country, really, we need to collaborate with our other countries to ensure that in case a transaction ends in Kenya or in Tanzania, and you can track an initiation from a different country, then our enforcers need to collaborate and ensure that we find a way of bringing these fraudsters to book. But I do not know of any case where they have successfully apprehended perpetrators of this international fraud. All I know, once I handled a situation where I think it was about tapping into a system of an aggregator, and some of the phone numbers that had been used in disseminating the loot from the action of this transaction was in Kenya, in Sudan, in places like that. And the police, in their investigations, they will stop at that particular point where the jurisdiction ends. And so if there was a back-end collaboration in which the police here can, collaborate with the police in South Sudan, if they can track those individuals. But again, you find in these situations, there's a cost, and the cost is usually it goes to the person trying to actually recover. And so, because of the uncertainty of this recovery, you find that the person who's pushing it will rather not incur more money to apprehend something that they are not sure they will actually apprehend. If someone is beyond your reach, sometimes you have no incentive to actually go after them. If the police does the investigations and they say, oh, these are the numbers, and sometimes these numbers have been deactivated, there's no, they were fictitious, they were never registered in any person's name. So the cost of chasing that, who is going to bear it? The individual does not want to put in money, because the police will need to be facilitated. Yes, the police will need to be facilitated, and this facilitation comes to an end. You weigh the benefit of pursuing this cause, or you count your losses and reinforce your systems to ensure that you're not a victim again.
Thank you very much, Agatha, for that. I'm still hoping that we can get a question or two from the audience before we close. But as we do that, Ian, I want to revert to you. We're still trying to grapple with Islamic banking. And one of the principles you told us about is that Islamic banking does not support speculation. And in our traditional banking sector, we have products, especially over-the-counter derivatives, products, for instance, repos, and most of those products that would most likely seem to are based on speculation, especially on the forex exchange rates and all that. So does that now go away if it comes to Islamic banking? Can I not approach Islamic banking and I seek to get a product, an over-the-counter derivative product, like a repo, for instance?
Yeah, thank you. You'll find that your question is quite interesting, because most of the derivative contracts are usually oil contracts, and most of the oil is in the Arab world, and the Arab world supports Islamic finance. So answer to your question, you actually can. The certainty we're talking about is, maybe I can go into a little bit of derivative contracts. There's what they call forwards, put options, and all other types of contracts in derivatives. And what those forward contracts do, they more or less have a certainty. I could probably say the oil price right now is, let's say, 10 cents to the barrel. And if I buy it 6 months from now, it could have gone to 12 cents to the barrel, but it could also be 9 cents. So you look at that particular thing, you do a permutation and say, let's stop at, if it could be 12 and 9, let's stop at, let's say, 8.5, give you an example. And you say, I'll buy this particular barrel at 8.5 in the next 6 months. Now, there could be instances where that barrel could be 7, could be 10, could be any price, but you've settled at a price of 8.5. At that point, you'll buy it at 8.5 regardless of the price in the world market. So there will be a loss, there will be a gain to someone. But what Islamic finance comes to do is to give a certainty, to say, if I'm buying a particular, let's say a mobile phone at 2 million shillings today, and I'm going to pay back within a period of 6 months, and I'm going to pay back 2.5 million, it will be 2.5 million, not 2.6, not 2.3, not 2. It's that certain. There's that certainty of I'm not going to be charged an extra penny for what I've done. So the next 25 years, or the next 5 years, or the next 6 months, I will know this is for sure what I will pay back, not a penny more, not a penny less. And if there's any profit, it will be shared in this particular respect. If there's a loss, it will be shared in this particular respect. So the certainty is, I know for a fact what I'm going to spend on this particular asset, on my finance, on my asset. So yes, there are Islamic derivatives as well, and I've explained on the basics of oil contracts, but on certainty, that's what it means, that there will be no speculation. On conventional finance, on the other hand, if I take a mortgage today and I'm going to spend 25 years, I don't know how much I'm going to pay back in 25 years. It could be 300 million now and probably 500 million later. But for Islamic finance, I will tell you it's 300 million now, you're going to pay back 350 million in 25 years, and that will be it.
Wow, thank you. I'm sure there's more questions that are going to come up later, but for purposes of today's discussion, I'm afraid that they are having.
Maybe I'll just add something.
Yeah, sure.
Agatha's discussion is a little bit interesting on financial fraud and securities. I would urge maybe the audience to if you listen to podcasts, maybe listen to a podcast called Lazarus Heights. It's quite interesting on financial fraud around the world and how these people bounce off numbers and how they initiate billion-dollar transactions and cross-border, how you can get someone who has stolen money in the US or the UK or Pakistan, seated in Dubai or seated in Kenya, how you can they can be arrested to bring them to book. So it's interesting that sometimes just a mere email that can come in and cause financial fraud. Sometimes it's an instruction to certain machines in the bank. So it's interesting. But if you want to get more about financial fraud around the world, I think that podcast is good and it breaks down on different things that happen in the world.
Thank you very much, Ian, for that. And do you have any parting shots?
Thank you very much. Parting shots is we are conducting Islamic finance training effective 2024 at the Islamic Hub. Please watch out for details. We're doing a Sukuk training first quarter of the year 2024 with the Cambridge Institute of Islamic Finance as well as ISFIN. So those interested in Islamic finance, you're very welcome. We shall share that information. But generally, this is not Muslim finance. Please don't take it as Muslim finance. Anyone can access Islamic finance. The market is going to be open, and we hope the market will grow in that particular respect. Thank you very much.
Thank you. Mr. Pateka, any parting shots?
Thank you. With sustainability standards, I hope that in the coming years, we shall not have any collapsing bank in Uganda. It's my prayer that all financial institutions take up these standards, let us on board, so that we see institutions live longer and also our people getting jobs, thereby impacting on the economy. Thank you.
Over to you, Anne. Any parting shots?
Thank you, Keith. With taxation, it really comes down to compliance, and it comes down to your attitude towards compliance. And what we've seen is the bills from tax can actually close businesses, even though we know that banks are quite big players in the economy. Sometimes it can actually cripple a business. So it's important for a business to in the financial services sector to take compliance very seriously, onboard the lawyers, onboard the tax advisors, have the auditors who actually provide quality and ensure that you comply with regulations that are also outside your operation regulator compliance requirements, because you're operating in an environment where the regulators are not sleeping. URA is under immense pressure to collect, so you do not want to be the one who's financing URA's activities because of non-compliance. Thank you.
Thank you very much for those parting shots. Agatha Ninsima has just stepped out on an emergency, but we do recognize her presence, and we in the same manner recognize the presence of all the different panelists. Mr. Ian Mutibwa, or Managing Partner at Signum Advocates, Mr. Pateka Emmanuel, Head Legal at Postbank, Ms. Anne Kakuba Naziri, Tax Manager at BDO East Africa. I would also like to say that I've been privileged to have Mr. Innocent Damulira, who is a partner at DIT Advocates. He's going to be speaking tomorrow, but we're very fortunate to have him here. And remember that this is a CLE accredited program. 10 CLE points are up for grabs. And to confirm that, I have Emmanuel here, who is a member of the CLE committee, to confirm that all the participants are going to be getting their CLE points. But I also have Ms. Winfred Maiga, who has also been here with me at the Banking Institute in Buganda, at Uganda Road. For today's discussion, I want to thank our audience who have been very keen to follow the different speakers that have been speaking today, and also encourage you to still turn up tomorrow for another interesting set of conversations with different speakers that you're going to find resourceful. I've been called Namara Keith Charuzi, your host today. See you tomorrow. For today, it's goodbye.